All right, good afternoon again, everyone. Before we get started, I would just ask both sides to take a look at the participant list and confirm that you have everyone you need.
Plaintiff's got everyone, Your Honor.
Great.
Defense has everyone as well.
Okay, wonderful. And it looks like that all three of the scoring jurors are in the participant list. Before we get started, I would just ask the scoring jurors, if you have a conflict, let me know. And I'll assume that there are none then. Although I guess first I should ask folks to enter their appearances. So let's begin there with entry of appearance from the plaintiff, please.
Good afternoon, Your Honor. My name is James Betzelos, last name spelled Betzelos, and I, along with my co-counsel,
Alice Vagan, last name spelled Vagun.
we represent the plaintiff, Mr. Cam Donaldson.
Thank you. From the defense?
Good evening, Your Honor. My name is Shannon Reed, last name spelled R-E-I-D, on behalf of the defendant, Karen Baja, who is also on call with us this evening.
Good evening, Your Honor. Tanaz Nur Mohammadi, last name spelled Noormohammadi, representing the defendant, Karen Baja. And the defense has 2 motions in limine and 4 housekeeping matters to address today.
Okay, we will get there in just a moment. I'll just ask the scoring jurors again, if after hearing those names you have any conflicts, let me know. And I'll assume there are none. And then I think I am supposed to remind everyone, particularly I think the scoring jurors, to turn off your video during this part. And it looks like your video is off, so we're in good shape there. All right, is the plaintiff ready to proceed with this matter?
Your Honor, before we proceed to opening statements, the plaintiff has a few preliminary matters as well as one motion for the court's consideration.
Okay, we'll get there in a moment. And the defense appears ready to proceed with this matter as well. Is that correct?
Yes, Your Honor.
Okay. Right. One second. I have to do the swearing in first. So I'd ask all of you to raise your right hand. Please indicate by saying "I do" if you swear to abide by the rule of this proceeding and conduct yourself in a manner that is honorable to this forum.
I do.
I do.
All right. Thank you. Now calling case number 082263, Cam Donaldson versus Karen Baja. First, any preliminary non-substantive matters from the prosecution?
From the plaintiff, Your Honor, yes. That's okay. May we presume that all objections are heard outside of the presence of the jury, or should we ask to be heard outside the presence of the jury?
I would prefer that you ask.
And may we presume that all witnesses have been constructively sworn in?
Yes.
Now, Your Honor, at this time, the plaintiff moves to invoke Federal Rule of Civil Procedure, Rule 615, to have all witnesses aside from the defendant constructively excluded from the courtroom.
Any objection to that from the defense?
Your Honor, we request that experts be allowed to stay in.
Any objection to that from the plaintiff?
Yes, Your Honor. Pursuant to the Federal Rule of Civil Procedure, Rule 615, we do request that all witnesses aside from the defendant are excluded from the courtroom.
Okay, help me understand this. Are there the experts in this case? Are they responsive to one another? That is, they both opine on the same things?
The plaintiff, Your Honor?
Yes.
They opine to similar things. However, they are different types of investigators.
Okay. Here's what I'm going to do in this instance. Ordinarily, when there'd be a chance to present a rebuttal case, I would allow the experts to be in the courtroom for the testimony of their corresponding expert, so the expert who is opining on the same issues that they are. However, given the rules of this forum, there is no rebuttal case, so I'm not going to allow that. So I will grant the plaintiff's motion to sequester all witnesses. Anything else from the plaintiff?
Yes, Your Honor, we do have one motion. Turn to my.
Okay, second. Preliminary matters from the defense.
Yes, Your Honor. Does Your Honor have a preference that we tender our experts?
Good question. Typically, the practice of this court is not to tender experts in front of the jury.
Would Your Honor prefer that we stand up for objections, or may we remain seated?
You may remain seated in this bizarre world that we're in.
Your Honor, may we be permitted to stand for our opening and closing arguments and remain seated for our direct and cross examinations?
Under the circumstances, you can sit or stand as you like.
And during the course of the trial, counsel may request for a sidebar. We request that this be constructively approached and on video conference so that our evaluators are able to hear our arguments.
That is granted.
No further housekeeping matters, Your Honor.
Okay, let's hear the plaintiff's motion.
Your Honor, we are seeking a pretrial ruling on the admissibility of a petition for a temporary restraining order, which has been bait stamped in the record as 0016. For Your Honor's edification, the petition was filed by the deceased Lou Donaldson against the defendant in today's matter, Karen Baja, about 2 months prior to his disappearance. The statements contained within the petition for the restraining order are exceptions to the hearsay rule pursuant to Federal Rule 8033 and 804B1. Additionally, the statements fall under the exception for the residual exception to the hearsay rule pursuant to Federal Rule 807. If I may be heard, Your Honor.
You may. Could you tell me one more time what hearsay exceptions you think the statements fall in?
Under 8033, 804B1, and 807, Your Honor.
All right. Okay, go ahead.
With respect to the 8033 exception, the statements fall under the then existing mental condition exception because the statements contained within the petition indicate Mr. Lou Donaldson's then existing intent and plan to divorce the defendant Karen Baja. The statements also indicate how Mr. Lou Donaldson was feeling at the time, which was that he did not feel safe around the defendant. With respect to the 804B1 exception, the statement is exception under that rule as the declarant, Lou Donaldson, is currently unavailable. It was given at a prior court hearing regarding the petition for the temporary restraining order, and the witness, Mr. Donaldson, was subject to cross-examination at that hearing. And then finally, with respect to the residual exception to the hearsay rule, statements may be admitted if they are supported by sufficient guarantees of trustworthiness after considering the totality of the circumstances under which it was made, and it is more probative on the point for which it was offered than any other evidence than the proponent can obtain through reasonable efforts. Now, the very statements contained within this petition reflect a genuine fear for Lou Donaldson's own life, which is further evidenced by the very filing of this petition, as Lou Donaldson felt the only way to ensure his safety was to have the courts intervene and get a restraining order against the defendant. We're talking about a man who worked with lions and tigers on a daily basis, animals that could attack at any moment. And despite all that, his biggest fear remained his wife. When looking at the totality of the circumstances, it is highly unlikely that Lou Donaldson would lie in open court about why he wanted to get a divorce, about why he wanted to get a restraining order. And because Lou Donaldson is not here to testify to these statements, they have high probative value in proving that the defendant's motive. And it's for these reasons that we ask this court to rule in favor of the admissibility of the petition for the temporary restraining order.
Okay, response from the defense?
Yes, Your Honor. We object on the grounds of inadmissible hearsay, improper opinion, and that its prejudicial impact substantially outweighs its probative value.
Okay, any further argument from the defense?
Just those 3 objections, Your Honor.
Okay, one more time.
Inadmissible hearsay, improper character opinion, and its prejudicial impact substantially outweighs its probative value pursuant to Federal Rules of Evidence 403.
Okay, do you have a response to either 8033, why it doesn't fall within that exception, or 804B1?
Yes, Your Honor. In regards to the state of mind exception, we don't know Mr. Donaldson's state of mind. We don't know if he intended to seek a temporary restraining order to get a leg up from a divorce he may have intended to pursue. And because these are unilateral and unverified claims, we cannot determine the veracity of these assertions.
Okay, I have one question for the plaintiff. It looks like from the face of this that these were statements made in a pleading that was submitted to the court, not at a court hearing. Is there any foundation for the statement that these were statements given as a witness at trial or a deposition?
Your Honor, it was given, no, Your Honor.
Okay, here's what I'm going to do. I'm going to grant the motion in part. I think that statements 2 and 3 fall within 8033. I think statement 1 does not, so I will allow you to admit the TRO request, but statement 1 will be constructively redacted. Any other motions from the plaintiff?
None, Your Honor.
Your Honor,
Okay.
I'm sorry, just to clarify, so it's constructively redacted from the TRO. If we choose to use it in the close and it's up there with statement number 1, we can assume that it's been constructively redacted, correct?
That's correct, yes.
Thank you.
But thank you for clarifying. All right, motions from the defense.
Yes, Your Honor. Today, Ms. Karen Baja is being wrongfully accused of having caused the death of her husband, Lou Donaldson, simply because she inherited his estate and received his life insurance policy. Our first motion is to exclude evidence of Ms. Baja's prior juvenile conviction. One of the witnesses in this case claims to have knowledge of her prior juvenile conviction she received when she was 17 years old. And we move to exclude this evidence as being inadmissible under Federal Rule of Evidence 609B and D, as the conviction is more than 10 years old, and further inadmissible in a civil trial.
Okay, what is the plaintiff's position on that?
Your Honor, while I do take exception to counsel characterizing this as a wrongful accusation, we're here to try this case to find out what the situation is. We do not intend to elicit such testimony today.
All right, then, the motion's granted. Any other motions from the defense?
Yes, Your Honor. Our second and final motion is to exclude any reference to Ms. Baja's refusal to submit to a polygraph test as lacking in foundation and unduly prejudicial under Federal Rule of Evidence 403. And reference to this can be found on the second page of the report written by Taylor Pride.
Okay, can you help me out with the page number or somewhere else where I can find it?
Yes, Your Honor. Do you have a digital copy?
I do have a digital copy, yes. I'm looking at a PDF, 71 pages long of the case problem. So you can just tell me what page of the PDF if it's not Bates stamped.
It's page 17 of the PDF, Your Honor.
Thank you. Okay. And you are seeking to exclude or prevent this witness from testifying as to Ms. Baja's failure to submit to a polygraph under Rule 403, right?
Yes, Your Honor.
Okay. Response from the plaintiff.
Again, Your Honor, we do not intend to elicit such testimony.
Wonderful. That is easy then. I will grant the motion. Any other motions from the defense?
No further motions, Your Honor. The defense is ready for trial.
All right, let's proceed then to opening statement. First from the plaintiff.
May I proceed, Your Honor?
You may.
$10 million. We are here today because the defendant, Karen Baja, killed her husband, Lou Donaldson, for $10 million. 2 days after Lou Donaldson filed for a restraining order against the defendant, a new will suddenly appeared. Lou Donaldson's will was suddenly changed, so now that all of his estate would be awarded to the defendant in the event of his death or his disappearance. Now, 2 weeks after the defendant was heard arguing with Lou Donaldson when he told her he wanted a divorce, he suddenly disappeared. After that fight, he told his son, "If anything were to ever happen to me, I want you to be sure to have the police look into Karen, because she will be the one that is responsible for my death." 2 months passed between the moment that the defendant thought she was going to lose it all to the day that Lou Donaldson disappeared. The defendant waited patiently. Because you see, the defendant had grown accustomed to the lifestyle that Lou Donaldson gave her. And she wasn't going to let anyone, not even him, take that away from her. So she created a plan to forge his will and to kill him for $10 million. Members of the jury, my name is Alice Vagan, and I, along with my co-counsel, James Vatselos, represent the plaintiff in today's matter, Cam Donaldson. And it is our burden here today to prove to you all, by preponderance of the evidence, that the defendant, Karen Baja, is responsible for the wrongful death of her husband, Cam's father, Lou Donaldson. Now, when Lou Donaldson and Karen first met, he was 20 years older than her. He was a successful businessman. And the defendant, well, she didn't have much. She came from a poor upbringing. And when they met, Lou was married. He had a family, a wife, a son. But that didn't matter to the defendant because she saw her golden ticket in Lou Donaldson. So Lou divorced his wife, got together with the defendant, and together they opened up Wild Wild Life Tiger Emporium, a sanctuary dedicated to endangered animals and big cats. Because you see, for Lou, he wanted to create a safe space for these endangered animals because his life's work, his life's passion, was the preservation of these beautiful and majestic creatures. Now, the defendant, she just wanted a safe place for herself. Now, after they opened up Wild Wild Life together, Cam, Lou's son, came to work with him. And for more than a decade, they worked side by side every single day, realizing his dad's dream. But on August 17th, 2012, Cam said goodbye to his father for the last time. Now, at that moment, he didn't know that this was going to be the last time that he would ever see his dad alive. He thought he would see him back at the office on Monday morning. He thought that he could stop by his house on Sunday and there would be Lou cooking up one of his famous Sunday dinners. Cam is going to tell you all today that he saw his dad, a perfectly healthy man, with no plans to leave for any trip, walk out of that office door on Friday night and never come back. And that's because the defendant's lifestyle had been threatened. So she made sure that this was Cam's final goodbye. Now, you're also going to hear from Cam that the same weekend that his dad disappeared, the defendant broke into Wild Wild Life to steal a lockbox. A lockbox that contained Lou's will, the real one, the original one that he had actually signed, the one that had equally divided his estate between Cam, Cam's mom, the defendant, and Wild Wild Life. Now, you're also going to hear that This was the last time anyone would ever see this will, because the one that the defendant later presented in court gave her everything. The defendant didn't want a cut, no. She wanted it all. Now, you're also going to hear today that back at Wild Wild Life, they have a meat grinder. And this meat grinder can dispose of a human body. But you're going to learn that at least 2 people are needed to operate it. And you're also going to learn that in the early morning of August 18th, 2012, just a few hours after Lou Donaldson was last seen alive, the defendant was at Wild Wild Life with her brother. Her brother, the deputy sheriff at the Pioneers County Sheriff's Office. The same department that investigated the disappearance of Lou Donaldson, and the same one that would have arrested the defendant had she been charged with anything. Now, members of the jury, before we go any further, we need to confront a few basic realities here. Because the truth is, you're not going to hear about a body being found. You're not going to hear about DNA evidence being tested. You're not going to hear about blood being tested. No one here today is going to get up on that witness stand and tell you that they saw with their own eyes the defendant, Karen Baja, kill her husband, Lou Donaldson. But that's okay. Because here's what you will learn here today. A perfectly healthy man with a family, with no plans to disappear, disappeared without a trace after the defendant had threatened him multiple times. Members of the jury, Lou Donaldson is dead. In fact, you will all learn here today that it was the defendant herself who petitioned the court to have him declared legally dead, even though she had long known that already. Now, you will learn today that she made this difficult decision because it was time to move on, that it was time for closure. But the truth is, she needed him to be officially dead. That way, she can finally collect on his life insurance policy. And you're all gonna learn that the day, 5 years after he was last seen alive, she ran straight from the courthouse right to the life insurance company to collect her payout. Members of the jury, it is our burden here today to prove to you all by preponderance of the evidence that the defendant is responsible for the wrongful death of Lou Donaldson. And at the close of today's trial, once you've seen all the evidence, once you've heard all the testimony, it will be clear that we have met our burden. Because you're all going to hear how 2 days after Lou Donaldson tried to get a restraining order against the defendant, his will was forged to solely benefit her. That 2 weeks after they were last heard arguing and he told her he wanted a divorce, he suddenly disappeared. 2 months it took for the defendant to complete her plan to keep her lifestyle by any means necessary. At the end of today's trial, my co-counsel James Batzelis will come before you, and he's going to ask you all to deliver a verdict. He will ask you to find for a verdict that the evidence, the testimony, and that common sense and justice for Cam demands. We will ask you to find the defendant, Karen Baja, liable for the wrongful death of Lou Donaldson.
Your Honor, may I have a moment to adjust my camera? Your Honor, your screen appears to be frozen on my end.
Mine as well.
Same here.
Okay. Sorry about that. I think that was an issue on my end. Can everybody hear me okay?
Yes, Your Honor.
Yes, Your Honor.
Okay. Sorry about that. I did hear the entire end of the opening, so no need to repeat anything for my benefit. Is the defense ready to proceed?
Yes, Your Honor. May I have a moment to adjust my camera?
Certainly.
Your Honor, are you able to hear and see me from this distance?
Yes, I can see you just fine. Thank you.
May I proceed?
You may.
Members of the jury, no one here denies that Lou Donaldson's disappearance was devastating. On August 17th, 2012, Lou Donaldson made the decision to get on one of his planes, to fly with a suspended license and without a flight plan, and head to Costa Rica without saying a word to the people closest to him. That day wasn't the first time Lou Donaldson had left, but it was the first time he never came back. That day, plaintiff lost his father, and Karen Baja lost her husband. But instead of coming together to mourn their loss, Cam Donaldson has spent the last 5 years searching for someone to blame. And today, he's pointing the finger at his father's wife and heir, Karen Baja. Members of the jury, he can point the finger, but he can't prove the case. But before we go any further, I'd like to introduce you to Lou Donaldson's wife. Ms. Baja, can you turn your camera on, please? Members of the jury, this is Karen Baja. Since her husband's decision to leave, she's been running the Wild Wildlife Sanctuary, and she continues to this day to honor her husband's legacy by protecting and caring for the lions and tigers of the sanctuary. Thank you, Ms. Baja. You can turn your camera off. But today, the plaintiff is accusing Ms. Baja of the wrongful death of Lou Donaldson. As the judge will instruct you, the plaintiff can't just make accusations. He has to prove them. And today, the plaintiff will fail to prove his case because the evidence will show two things. First, that Lou Donaldson chose to leave his wife and son on August 17th, 2012. And second, that Lou Donaldson chose to leave his estate to Karen Baja. So let's start by taking a look at the first thing that the evidence will show, that Lou Donaldson chose to leave his wife and son on August 17th, 2012. Today, you're going to hear from Karen Baja herself. She'll tell you about the very first time she saw Lou Donaldson. It was love at first sight. He was her soulmate, and that it was their shared passion for big cats that brought them together. For 12 years, they worked side by side, dedicating their lives to protecting the big cats at Wild Wildlife. But we'll also learn that Lou Donaldson had another side, a secretive side. You'll learn about the planes he would regularly fly to Central America, planes that were unregistered, that didn't have flight plans, and that were piloted by Lou Donaldson himself on a suspended pilot's license. Today, Ms. Baja will walk you through the couple of months leading up to her husband's decision to leave. She and her husband are in what she believes is a loving and committed marriage. But then, all of a sudden, he says he's seeing someone else. She's in Costa Rica, and he wants to be with her. But not willing to give up on the connection and love they share, Ms. Baja tries to work with him to figure things out. But by August 2012, Lou Donaldson has made his decision. He's moving to Costa Rica, leaving his wife, his son, and his company behind. Now, it's August 18th of 2012, And Miss Baja has just finished a long evening caring for 2 newborn cubs that were rejected by their mother, when suddenly she realizes that her husband is gone. He's gone and he isn't coming back. And it's up to her to keep their passion project going the way her husband wanted them to. Which now brings me to the second thing that the evidence will show, that Lou Donaldson chose to leave his estate, including Wild Wildlife, to Miss Baja. Now, as we'll learn today, it was Miss Baja who shared her husband's passion for big cats. It was Miss Baja who cared for the cats. And it was Miss Baja who immediately turned her grief into action by continuing to run the Wild Wildlife Sanctuary and ensuring that all the lions and tigers were cared for in her husband's absence. Now, you're also going to hear a lot about Lou Donaldson's last will and testament, and the evidence will show that that will left the company to Miss Baja. Now, Cam Donaldson understandably was upset by that. He'll tell you that he thinks the company and everything should have gone to him. But the evidence will show that it was his father's wish that the estate go to Miss Baja. You're going to hear from Chris Reynard, a forensic document examiner who will come before you and explain how he utilized his decades of experience to determine that the will Miss Baja presented was Lou Donaldson's authentic last will and testament. Because you see, Lou Donaldson knew that by giving his estate, his company, his passion project, his life's work to the woman with whom he worked side by side for 12 years to preserve big cats was the easiest way to ensure that everything was going to be taken care of when he left. Members of the jury, throughout this trial, you're going to meet both Karen Baja and Cam Donaldson, and you'll see how they mourn the loss of Lou Donaldson. Miss Baja turned her grief into devotion for the big cat sanctuary. But Cam Donaldson is still in denial. Denial that his father left and denial that the estate was rightfully given to Miss Baja. But while he can point the finger, he can't prove the case. And that's why, at the end of this trial, my co-counsel, Tanaz Noor Mohammadi, will stand before you and ask you to return the only just verdict, the only right verdict, a verdict in favor of Karen Baja.
Okay, thank you very much. Is the plaintiff ready to call its first witness?
We are, Your Honor. We call Cam Donaldson to the stand. May I proceed, Your Honor?
You may.
Good afternoon, Mr. Donaldson. Can you please introduce yourself and spell your last name for us?
My name is Cam Donaldson, Donaldson.
You prefer I call you Cam or Mr. Donaldson?
Cam is okay.
Okay. Thank you, Cam. Can you tell us where you live?
Live right here in Pioneer in Statesville.
And how long have you lived here for?
I was born here, so all my life.
And can you tell us how you're related to Lou Donaldson in today's case?
Lou was my father.
Were you close with him?
I was extremely close with him. My dad was my biggest mentor and my best friend.
How often would you see your dad?
I saw my dad nearly every single day at work. I would often see him at home as well for Sunday dinners.
You just mentioned that you two worked together. Can you tell us where?
We worked at my dad's business called Wild Wildlife Tiger Emporium.
Can you tell us more about Wild Wildlife?
Sure. So Wild Wildlife is a sanctuary for big cats, particularly tigers. So my dad was very passionate about the protection and advocacy for large cats, and Wild Wildlife was a way for him to realize that passion and achieve his dreams.
Okay. And what was your specific role at Wild Wildlife?
So I was my dad's personal assistant for close to 20 years. For the past 10, I was my dad's assistant at the business. I wrote checks, cashed the checks, ordered supplies, I took my dad's schedule. Dad would often joke around that I knew more about the business than he did.
It sounds like a family business. Did mom also work there?
No, they were divorced at the time Dad started the business.
And around what time did your parents get divorced?
Was in spring of 2001, I believe.
Do you know if your dad was seeing anyone else after the divorce?
Yes, he was seeing the defendant, Karen. She's the reason they got divorced anyways.
Do you see the defendant in court here today?
Yes, I do.
Can you please point to her and identify her by an article of clothing?
Yes, she is sitting at defense counsel table wearing a gray jacket.
Now, let the record reflect that the witness has made an in-court identification of the defendant, Karen Baja.
Record will reflect.
Now, Cam, when your father first started seeing the defendant, what did you think about their relationship?
Well, she was 20 years younger than my dad, which I always thought was kind of odd. She never came from a really fortunate upbringing, so I was always worried that she might have been after his money.
Now, Cam, as you know, we're here today to discuss what happened to your dad. So can you tell us, when was the last time that you ever saw him?
Last time I ever saw my dad was August 17th of 2012.
Tell us more about your last moment with him.
Sure. So that day, it was like any other day at work. Dad was working hard as usual. And at around 6 p.m., when he was getting ready to leave, he said he'd see me on Monday. And unless I wanted to come for one of our traditional Sunday dinners. And I thought that I would see my dad.
Objection, Your Honor. Hearsay, move to strike. The statements where Mr. Donaldson testified that he would see me and join for dinner.
Response?
Your Honor, this statement is an exception to the hearsay rule under 8033 present. Mr. Donaldson's statement is describing his then existing state of mind, which was a plan to see his son either back at work on Monday or during one of their Sunday dinners.
Overruled.
Now, Cam, did you end up seeing your dad in the office on Monday?
No, that was the last time I ever saw him.
Well, was that unusual?
Yes. So, I mean, as I said, I was my dad's assistant and I wrote his schedule. So the fact that I didn't see him that Monday, I mean, that was particularly odd to me.
Well, did your dad go on a lot of trips?
Well, yeah. Dad was a pilot and he would often fly out of airstrips and airfields and take trips to places like Costa Rica. But at the same time, he would never leave without telling me or his family, especially me. And Dad would never fly without his glasses. He was blind as a bat without them.
So you just said that your dad would never leave without telling you or your family. Can you elaborate on that a little bit?
Well, as I said, Dad would often fly kind of at a moment's notice, and oftentimes he wouldn't log his flights because his license was suspended. But being so close with my dad, he said nothing to me about leaving that weekend.
Okay, now Cam, I want to talk to you about that weekend that your dad disappeared. Did anything unusual happen?
Yes, on Sunday of that weekend, there was the alarm went off at the office.
And what did you do?
Well, I live close by, so I figured I'd drive over and see because I thought we might have a break-in.
Okay. I'm now directing opposing counsel to what has been base stamped as 004 and 005. And I'm also directing the witness's attention to what has been base stamped as 004 and 005. Now, Cam, do you recognize these photos?
Yes, I do.
And how do you recognize the photos that has been base stamped as 004?
Well, that is a picture of the padlock that was on the front gate to our office.
And how do you recognize the photo that has been base stamped as 005?
That is a picture of the back entrance to our office.
Are these photos a fair and accurate representation of the padlock and the back entrance as you last saw them?
Yes, they are.
May the record reflect that I'm remarking what has been base stamped as 004 as Plaintiff's Exhibit 1 and what has been base stamped as 005 as Plaintiff's Exhibit 2. At this time, and striking all other identifying marks. At this time, plaintiff moves to admit Plaintiff's Exhibit 1 and 2 into evidence.
Any objection?
None, Your Honor.
Exhibits 1 and 2 are admitted.
Permission to publish Exhibit 1 and 2 to the jury by way of screen sharing.
Granted.
Now, Cam, was the padlock cut when you left work on Friday?
No, it was not.
So tell us, what are we looking at here?
That is a picture of the padlock on our front gate that has been cut.
And when did you see the padlock cut?
When I came to the office on Sunday, when I thought there was a break-in.
Okay, now moving to Exhibit 2. When you left work on Friday, was the back entrance broken into?
No, certainly not.
And what are we looking at here?
That is a picture of the back entrance to our office gate, and it looks like it's been busted into.
Now, when did you see the back entrance look like it had been broken into?
The Sunday I arrived at the office to inspect the break-in.
Now, when you arrived at the scene of the break-in, did you see anybody there?
Yes, I did.
And who did you see?
I saw the defendant, Karen, and some guy. I didn't know who he was.
Now, did your dad mention to you that Karen was going to be at the office over the weekend?
No, he did not.
Did Karen ever mention to you that she was going to be at the office over the weekend?
No, she did not.
So when you got there, what was she doing?
Well, she was walking out of the office and she was carrying something.
What was she carrying?
She was carrying a lock cutter. Oh, excuse me, a padlock. Excuse me, a lockbox.
Now, to clarify, she was carrying a lockbox with her?
Correct.
Now, the man that you said you saw her with, was he also carrying anything?
Yes, he was.
And what was that?
He was carrying a lock cutter.
Okay. I want to direct your attention back to that lockbox. Have you seen it before?
Yes, I have.
And where have you seen it?
That was the lockbox that my dad kept in his office.
Now, do you know what was inside of that lockbox prior to that day?
Yes, I do.
And how do you know what was inside of that lockbox?
I had seen it many times.
And can you tell us what was inside?
Yes.
And what was
My
it?
dad's real will, his last will and testament, not that one that Karen presented to the court.
Now, do you know how your dad originally planned to divide his estate?
Yes, I do.
And can you tell us how?
Yes. So my dad planned to split his estate in 4 quarters. The first and second quarter were supposed to go to me and my mother. The third quarter was supposed to go back into the business. And then the fourth quarter was supposed to go to Karen.
Now, you've told us now that you're close with your dad. Did he ever tell you about a second will?
He did not.
Did he ever tell you that he had any plans to change his original will?
Absolutely not.
So the will that was presented later in court, was that the one that was in the lockbox?
It was not.
Well, where did that will come from?
That will came from the defendant.
I'm now directing opposing counsel to what has been bait stamped as 0014, and I'm now directing the witness's attention to what has been bait stamped as 0014. Cam, do you recognize this document that has been bait stamped as 0014?
Yes, I do.
And tell us how you recognize it.
It is the will that Karen presented to the court.
And is this document a fair and accurate copy of the will that Karen presented as you last saw it?
Yes, it is.
May the record reflect that I am remarking what has been previously bait stamped as 0014 as Plaintiff's Exhibit 3, striking all other identifying marks. At this time, the plaintiff moves to admit Plaintiff's Exhibit 3 into evidence.
Any objection?
None, Your Honor.
Exhibit 3 will be admitted.
Permission to publish Exhibit 3 to the jury by way of screen sharing, Your Honor.
Granted.
Thank you. Now, Cam, tell us, how is this will, the one that Karen presented, different from the original will?
Well, you can see that this will awards Karen everything, my dad's business and his entire estate.
Objection, Your Honor. I would like to object specifically in regard to the highlighted portion on the last will and testament. This highlighted portion is not part of the original Bates 0014 copy, and it will mislead the jury into thinking that this will has that specific highlighting portion on the original will. Move to strike.
I will allow you to cross-examine on that point, but I'll admit the exhibit.
Now, Cam, what was the total value of the estate?
My dad's business and the insurance policy, that was $10 million.
Okay, now, can you please read to the jury the highlighted portion of the last will and testament?
Yes, I can. I appoint Karen Bozia to be the sole executor of this will, and if I should die or disappear, I give to Karen Bozia absolutely all my real and personal property whatsoever.
Now, Cam, is there anything about this language that struck you as odd?
Yes, it did. So, I mean, disappear? I mean, people certainly plan on dying. That's why they hire lawyers to write wills, but people don't plan on disappearing.
Objection, Your Honor, improper opinion.
Response?
Your Honor, we're not asking Mr. Donaldson for his expert opinion. We're simply asking him his opinion as a lay witness, what he thought of the language.
Overruled.
Now, Mr. Donaldson, or Cam, my apologies. When did the defendant provide this will?
He provided it 1 month after she had my father declared legally dead.
And do you know the specific date that was?
That was August 18th of 2017.
Okay, so by that time, by that date, how much time had passed since he was last seen?
5 years on the dot.
Now, Cam, you've told us multiple times now that you and your father were very close. So, to your knowledge, do you know if he had any enemies?
Not to my knowledge.
Do you know if he was seeing anyone else other than the defendant?
Not to my knowledge.
Do you know if he had a plan to fly away to Costa Rica on Friday, August 17th, 2012?
Absolutely not.
Do you know if he had any other vacations planned during that time?
Absolutely not.
So tell us, what do you think happened to your dad?
Plain and simple, Karen killed my dad.
Objection, Your Honor, improper opinion. Move to strike entire statement.
Sustained.
Prior to your dad's disappearance, how was the defendant's and your father's relationship?
Well, it was not very good. Dad did move to petition the court to get a TRO against Karen.
And are you aware of the outcome of that petition?
Yes, I am. It got denied, and that really set me on edge.
I'm directing opposing counsel to what has been bait stamped as 0016, and I'm now directing the witness's attention to what has been bait stamped as 0016. Your Honor.
I'm sorry, sorry to interrupt. Was there an objection from the defense? I saw your.
Yes, Your Honor. I objected to lack of foundation. Move to strike. Specifically in regards to Your Honor, withdrawn.
All right, I'm sorry, Ms. Vaughn, continue.
Your Honor, the petition for the temporary restraining order has been stipulated as being authentic, and it's time we are seeking to offer it into evidence. It has been previously ruled by Your Honor that it is admissible, particularly to the statements 2 and 3 within the petition, and the first has been constructively reducted.
All right, this is Exhibit 4.
Yes, at this time, we are plaintiff is remarking what has been previously bait stamped as 0016 as plaintiff's Exhibit 4, striking all other identifying marks. And at this time, we move to admit it into evidence.
Exhibit 4 is admitted.
Permission to publish Exhibit 4 to the jury by way of screen sharing.
Granted. And I will just interject quickly for the benefit of everyone. Once an exhibit is admitted, you're free to publish via screen sharing at any time.
Thank you for the clarification, Your Honor. Cam, can you please read to us lines 2 and 3?
Objection, Your Honor. Lacks foundation. Plaintiff's counsel has not laid any foundation that Mr. Donaldson saw this temporary restraining order, just that he's aware of it and that it was denied.
Response?
Your Honor, I could lay foundation. I can lay more foundation.
All right, I will allow you to do that.
Now, Cam, prior to your dad's disappearance, were you aware of any issues in your dad's marriage with the defendant?
Yes, I was.
And to your knowledge, did he ever indicate to you that he felt unsafe?
Yes, he did.
Now, to your knowledge, do you know if he ever asked the courts to intervene?
Yes, he did.
And how did he ask the courts to intervene?
He petitioned to receive this TRO.
Now, later, did you become aware of this petition?
Yes,
Did you become aware why the petition was denied?
yes, Dad told me.
Now, can you please read to us lines 2 and 3 of the petition for the temporary restraining order?
Sure. Line 2. I am seeking a divorce from Karen Baja. Line 3. I do not feel safe around Karen Baja.
Now, Cam, how close were those statements made to the time that your dad disappeared?
Was about 2 months before Dad disappeared.
So after this temporary restraining order was denied, did you observe any other arguments between them?
Yes. Particularly 2 weeks before my father disappeared, Karen and my father had a huge fight at the office.
Okay, I want to direct your attention to 2 weeks before your dad disappeared to that specific fight. What happened?
Well, we were just getting ready to close and I was at the office and I heard a very loud commotion from my dad's office, and Karen immediately stormed out. And as I went to check and see what was going on, see what happened to my dad, he came out, and I had never seen my father like this before. He was shaking. And I asked him, Dad, what happened? What happened? Did you have a fight with Karen? And what Dad said to me,
Objection, Your Honor, for hearsay.
All right, why don't we step outside the presence of the jury for just a moment. Ms. Vaughn, what's this witness going to say?
Your Honor, this witness will testify to the fact that that his father told him if anything were to ever happen to him, he wanted to be sure to have the police look into Karen because she will be the one responsible for death. This statement falls under the then existing state of mind exception to the hearsay rule pursuant to 8033. Mr. Donaldson's statement indicates his then existing state of mind, which was Lou Donaldson's plan for his son to have the police investigate the defendant in the event that something had happened to him.
Response from the defense?
Your Honor, the last part of plaintiff's response cut out for me. May I request that it be repeated once more?
Is my connection all right?
I can hear you just fine, yep.
Okay, so I indicated to the judge that under 8033, Mr. Donaldson's statements indicates his then existing state of mind, which was that Mr. Lou Donaldson's plan for his son to have the police investigate the defendant in the event that something had happened to him.
It is, Your Honor.
I'm sorry, did you have any further response to 8033?
None, Your Honor.
Okay, so do you still object?
Submitted.
Okay, so I will overrule the objection.
May I proceed, Your Honor?
You may.
Now, Cam, tell us, what did your dad tell you after this fight?
my dad told me, again, something I'll never forget. Son, if anything ever happens to me, you have the police look into Karen Baja because she will be responsible for my death.
Now, Cam, I understand this may be difficult for you, but can you please tell us, how has your father's death affected you?
Well, I mean, it's affected me in every way. I lost my best friend. I lost my biggest mentor. I lost my dad. I lost my work buddy. My dad was the hardest working man I ever knew. Nothing, no adversity in his life stopped him from achieving his goals.
Objection narrative.
Overruled.
You please continue, Cam.
Yes. Nothing my dad ever, any adversity he experienced, it didn't stop him from achieving his goals. My dad was a self-made man, but I think most importantly, he was a good man.
I'm directing opposing counsel to what has been bait stamped as 003, and I'm now directing the witness's attention to what has been bait stamped as 003. Cam, do you recognize this photo that has been bait stamped as 003?
Yes, I do.
And tell us, who is this a picture of?
It's a picture of me and my dad. It's actually my favorite picture of us. He used to swing me around in circles like that when I was a kid. And I wanted to be just like my dad. So I always thought that that's what it was like when he would go up in the air and fly it like a pilot.
Does this photo depict your father as he appeared in real life?
Yes, it does.
May the record reflect that I'm remarking what has been bait stamped as 003 as Plaintiff's Exhibit 5, striking all other identifying marks. At this time, plaintiff moves to admit Plaintiff Exhibit 5 into evidence.
Any objection?
None, Your Honor.
Exhibit 5 is admitted.
Okay, now, Cam, tell us, what do you miss most about your dad?
Well,
Objection, Your Honor, irrelevant.
Your Honor, if I may respond.
You may.
As part of our case today, we will be arguing non-economic damages, and this photo is relevant in establishing the grief, the loss, and the pain and suffering that Cam has experienced, that Mr. Donaldson and his family has experienced as a result of the defendant's actions. And this photo is relevant because it helps the jury better understand that Mr. Donaldson was a family man and fully capture the loss that Cam has experienced.
Is this case bifurcated at all? Is the damages phase bifurcated, or is it all one?
It's all one, Your Honor.
Okay. On that basis, then, the objection's overruled.
Now, Cam, can you please tell us what you miss most about your father?
so I think the hardest part about not having my father in my life anymore is it's really difficult to go from seeing somebody nearly every day of your life to, in a moment's notice, not at all. My dad is the first thing I think about when I wake up, and he's the last thing I think about when I go to bed. I can't even put into words how much I miss my dad. And I really think it's one of the toughest things to lose a parent.
Thank you, Cam. Your Honor, may I have a moment to confer with my co-counsel via the Zoom chat feature?
Yes, of course.
Your Honor, nothing further.
Okay, cross-examination.
Yes, Your Honor. Mr. Donaldson, I know this might be hard, but I need to ask some questions about your father. Now, in addition to being a businessman, your father was a pilot.
Correct.
He owned multiple planes.
Correct.
And months before his disappearance, he had a suspended pilot's license.
Correct.
And that's why he would sometimes fly without logging flight plans with any of the local airports.
Correct.
And you don't know how many planes he owned.
Correct.
You do know that some of those planes weren't registered.
Correct.
Now, August 17th, 2012 was the last day you saw your father.
Correct.
On direct, you shared how hard it was to lose your father.
Correct.
But you didn't try to look for your father after he was identified missing.
Correct.
You didn't try to call him.
Well, I wasn't sure where he was.
Is that a yes?
Yes.
You didn't try to text him.
Correct.
You didn't try to search for any recent reports of plane crashes in the area.
Well, I just didn't know what was going on. I wasn't sure.
Is that a yes?
Yes.
You didn't try to determine if one of his planes were missing.
Correct.
You did, however, hire a private investigator,
Yes, I did.
but that wasn't until 2017.
Correct. That was because Karen declared my father legally dead.
Well, it was in 2017 you discovered that Karen Baja got the $5 million life insurance policy.
Correct.
Now you're the plaintiff in this matter,
Yes.
and you're challenging Mr. Donaldson's last will and testament.
The last will and testament Karen produced to the court. Yes.
But you didn't file a lawsuit in probate court.
I just did what my lawyers told me.
Is that a no?
Correct.
You did not file a lawsuit in probate court?
Correct. I did not.
And you're challenging Ms. Baja's receipt of the $5 million life insurance policy,
Correct.
but you're not suing the insurance company.
Correct.
Instead, you brought a wrongful death lawsuit
Correct.
and you're suing Ms. Baja.
Objection asked and answered.
Your Honor, I have not asked I have not asked this question.
Ruled.
And instead, you're filing a wrongful death lawsuit
Correct.
because it's only through a wrongful death lawsuit you could win both pots of money with one action.
I believe so.
Improper opinion.
Overruled.
Now, I'd like to talk to you about your relationship with Ms. Baja. Ms. Baja is not a recent acquaintance.
Correct.
You met her after she started seeing your father.
Correct.
And when your father met Ms. Baja, he left your mother,
Correct.
and then he married Ms. Baja,
Yes.
making Ms. Baja your stepmom.
Yes.
And you've never liked your stepmom, have you?
Correct.
In your own words, you hate her.
Yes.
Now, you remember giving testimony in a prior deposition in this matter,
Yes.
and at that time, you were asked questions and you answered them.
That's how it works. Yes.
Improper impeachment.
I'll overrule the objection for the time being. I'm not sure exactly where this is going. You can continue, counsel.
At that time, you were asked to raise your right hand and swear to tell the truth.
Yes.
You did tell the truth.
Yes.
And at that time, at that testimony for your prior deposition, you gave a full and complete statement of everything that happened.
Yes.
Directing court and counsel to pages 23 to 26 of Cam's deposition if you're utilizing a PDF.
I'm sorry, opposing counsel, can you repeat that to page 23, you said?
It's page 23 of the PDF, starting on page 3 and ending on page 26. Isn't it true that nowhere in your prior deposition did you ever state that your father told you about the temporary restraining order?
Well, I was my dad's personal assistant, and we've had many conversations. Whether it was asked about in a deposition or whether I remembered to mention it. I mean, that's just something I'm not really sure.
So is that a yes to my question? Nowhere in your prior deposition did you ever state that your father told you about the temporary restraining order?
Yes.
Your Honor, objection improper impeachment may I be heard outside the presence of the jury or a sidebar?
Yes.
Your Honor, on page 26, if you're referring to a PDF document in the record, it explicitly states, and if I may read, however, the court in all its wisdom denied the restraining order. It ruled that the death threat did not present enough credible evidence of an actual threat of bodily harm. I guess the words "I'll kill you" were not clear enough. Although it does not specifically state that Lou Donaldson himself said these words, it is clear that Cam Donaldson has the prior knowledge to testify as to the petition for the temporary restraining order.
I think that's an issue for redirect, counsel.
All right, withdrawn, Your Honor.
You may continue.
Yes, Your Honor. Now, you're challenging the last will and testament Ms. Baja presented to probate court, correct?
Correct.
And you mentioned that there was a prior will.
Yes.
But you didn't bring a copy of that will with you today, did you?
Correct. I don't have a copy of the will,
In fact, according to you, there are no copies of that will.
not that I'm aware of.
So we're just going to have to take your word a prior will existed.
Correct.
Now, that prior will gave you 25% of your father's assets, correct?
Yes.
But today, you're not just asking for 25%.
Correct.
Today, you want it all.
I want what is fair.
Is that a yes to my question?
Do I want it all?
You are seeking both the life insurance policy worth $5 million and the company valued at $5 million.
I just want justice to be served properly for my father. That's all I want. I don't care about the money.
Mr. Donaldson, isn't it true that if you win on this case, you will win $10 million?
That would be nice. I'd love to win $10 million, but I want what happened to my dad to be brought to light.
Mr. Donaldson, is the answer to my question yes, that if you win on this case, you will win $10 million?
Yes.
No further questions, Your Honor.
Okay, redirect.
Yes, Your Honor. Cam, I just have one question for you. Do you know if your dad attempted to get a temporary restraining order against the defendant Karen Baja prior to his disappearance?
Yes.
Nothing further, Your Honor.
Okay, Mr. Donaldson, I think you are excused. Plaintiff, please call your next witness.
Thank you.
Yes, Your Honor. At this time, the plaintiff calls Mr. Taylor Pride to the stand. May I proceed, Your Honor?
Yes, you may.
Good afternoon, Mr. Pride. Could you please introduce yourself to the members of the jury, spelling your last name for the record?
Good afternoon. My name's Taylor Pride. Last name's Pride.
Where do you live, Mr. Pride?
I live here in Statesville. Lived here my whole life.
What do you do for work?
Currently, I run my own business, Pride Investigations, Inc., and I'm a private investigator.
Were you hired to conduct a forgery investigation in today's case?
I was, yes. I was hired by Mr. Cam Donaldson.
Do you know who Karen Baja is?
I do. She's the defendant.
Do you see Karen Baja in the courtroom here today?
Yes, I see her constructively over there in the white shirt.
May the record reflect this witness has identified the defendant, Karen Baja.
Record will reflect.
Now, Mr. Pride, before starting your own private investigator firm, did you work anywhere else?
I did, yeah. Before I started my own firm, I worked at the Pioneer Police Department.
What was your job at the Pioneer Police Department?
Well, I started out as a patrol officer, but for the majority of the time I worked there, for about 16 years, I worked as a detective.
Now, as a detective during those 16 years, did you ever investigate any forgery investigations?
I did, yes. For 6 of those 16 years, I worked at the economic crime unit at the Pioneer Police Department. And in that specific unit, pretty much all we did was look at forgery and, economic crime.
Sure. Does investigating forgery cases require any sort of special training?
It does, yes.
And what training process did you go through for investigating forgery cases?
So the specialty that I have is in handwriting analysis and document examination. Over the course of my career, I've undergone a lot of training for that.
Could you elaborate on that training?
Yes. So I've done multiple seminars with the American Association of Handwriting Analysis, as well as with the American Board of Forensic Document Examiners. And I keep up to date on an annual basis. I take an 8-hour course with the Board of Forensic Document Examiners, just to keep up with the most current methods and practices in the field.
Sure. Do you have any certifications in the field?
I do, yes. I'm certified, again, by both the American Association of Handwriting Analysts and the American Board of Forensic Document Examiners.
And are you still certified today?
I am, yes.
Have you ever testified in court before today regarding a forgery investigation you conducted?
I have, yes. I've testified about 15 times over the course of my career.
Were you qualified as an expert during those 15 times?
I was. I was qualified as an expert in handwriting analysis and document examination.
Now, Mr. Pride, before we get to the specifics of this case, could you walk us through the process you go through in forensic document examinations?
Yeah, absolutely. So it's a 3-step process. And the first step of the process is collecting sample signatures from the person that we're analyzing.
Could you give us some examples of the samples you collect during this first step?
Yeah, so examples of things we collect are journals, signature pages, really anything that has someone's handwriting on it, we like to collect just so we can build a profile of that person's handwriting.
And then after you collect these samples, what's the next step in your process?
The second step of the process is what I just mentioned. It's building that profile. So we compare the known samples that we've collected, and we build a profile based on certain characteristics of the writing.
Could you give us some examples of the handwriting characteristics you identified during the second step?
Yes. So some of the characteristics are things like stroke, angles, how hard someone pushes down their pen, the way they write particular letters. And there's multiple characteristics that we kind of put together in our analysis and build a profile of someone's handwriting overall.
And you mentioned building a profile of someone's handwriting. What exactly does that entail?
So that entails looking at a few different pieces of their handwriting. And as I said, comparing things between the known signatures or pieces of writing and seeing what is the common things that people do when they're writing specific letters, writing specific words, and that kind of.
Sure. And aside from this 3-step process, is there anything else that's commonly looked at in your field in regards to a forgery investigation?
Yes, there's only so much you can really get from doing a handwriting analysis alone. So it's also important for us to always look at the surrounding circumstance of a particular case and bring the context into that handwriting analysis.
Now, let's turn to the facts of this case. Is that 3-step process you just mentioned, including the surrounding circumstances that you look at, the same process you went through in your forgery investigation for this case?
It is, yes.
So for the first step, where you said that you collect samples, what samples did you collect?
So we collected 3 samples for this case. We collected a note that Mr. Donaldson had written to his son. We collected a restraining order that he had signed, and we collected his driver's license signature.
Mr. Pride, is there a specific number of samples that need to be collected during this step of your process?
No, there's no specific number. We just look for a few samples that can give us a good idea of what the similarities are between someone's known signatures.
So were the samples that you collected in this case sufficient?
Yes, absolutely.
Now, Mr. Pride, for the second step in the process, where you mentioned that you look at the handwriting characteristics of the author, were you able to do that in this case?
Yes, I was able to what we call build a profile of Mr. Donaldson's handwriting based off the different known signatures that we had. So I was able to look at slant, the angles, the smoothness of his lettering, and with that, I built the profile that I used.
Now, would showing you the temporary restraining order paperwork, the signature on it, assist you in explaining to the members of the jury the handwriting characteristics you identified of Mr. Donaldson?
Yes, it would.
Directing opposing counsel to what has already been entered into evidence as Plaintiff's Exhibit 4. Mr. Pride, could you please turn to Plaintiff's Exhibit 4?
Yes,
Do you recognize Plaintiff's Exhibit 4?
I do.
And what do you recognize Plaintiff's Exhibit 4 to be?
I believe it is the restraining order that Mr. Donaldson signed.
Is Plaintiff's Exhibit 4 a true and accurate copy of the restraining order paperwork you looked at during your investigation?
It is.
There you go. Co-counsel, if we could just zoom in to the signature for the witness, please. Thank you. Now, looking at the signature here, Mr. Pride, what handwriting characteristics of Mr. Donaldson's did you identify?
Yeah, excuse me. So I won't go too far down the rabbit hole, but some of the things that we look at, for example, are in this first letter, the L. We look at things like the fact that the top loop is much smaller than the bottom loop in that L. We look at things that like the letters are all connected. It appears that Mr. Donaldson only raised his pen once from when he was writing his first name to when he started writing his last name. And we also look at things like for example, when Mr. Donaldson wrote Donaldson, he squished the O very close to the D. We call that a lazy letter. So it's those types of things that we look for to build a good profile of what someone's handwriting generally looks like.
Okay, and Mr. Pride, you mentioned that the third step of this process is to compare the handwriting in question to the samples that you collected. Were you able to do that in this case?
I was, yes.
Would showing you the will signature next to the temporary restraining order signature we were just looking at assist you in explaining to the members of the jury what you found when you compared these two documents?
Yes, it would.
Directing opposing counsel to what has already been entered into evidence as Plaintiff's Exhibit 3. Now, Mr. Pride, what did you find when comparing these two signatures?
So I found a few different things. One of the things that struck me right off the bat was what I just mentioned about.
Objection, Your Honor. May we maybe constructively approach? I'm sorry, Your Honor. I believe you're on mute.
You may approach, yes.
Your Honor, neither of these two exhibits were admitted in this form with signatures highlighted, and these documents have been edited. These were not how they were entered into evidence.
Are you seeking to admit this as an exhibit?
No, Your Honor, not how it is up here. This is just for it's a demonstrative for the jury.
Okay, I will allow it as a demonstrative.
Thank you, Your Honor. May I proceed?
You may.
Now, Mr. Pride, you were saying the differences that you found when you looked at these two signatures?
Yes. So as I mentioned before, one of the big differences I saw right away is that in the restraining order, Mr. Donaldson hardly lifts his pen off the page, whereas in the will, there's a few different instances, even within one letter, where you can see the pen being lifted off the page. Now, we also can see that the letters aren't as squished together in the will, and in addition, the restraining order signature is very smooth. It's clean. It appears to be from someone who's written this signature a lot. Whereas the signature in the will is shaky and it looks like someone who is nervous and trying to copy down something that they've seen before.
Now, Mr. Pride, aside from this three-step process you just mentioned, you also told us you look at the surrounding circumstances. Were you able to do that in this case?
I was, yes.
And what, if anything, did you find when looking at the surrounding circumstances?
Well, one of the most important things for wills in particular is to speak to the witnesses of the will. So I was able to speak to the witnesses, and in particular, Miss Samantha Lane.
And what did Ms. Lane tell you?
Objection calls for hearsay, lacks foundation.
Response?
Your Honor, in response to the hearsay objection, pursuant to Federal Evidence 703, this hearsay statement is used as part of what this witness looked at to come to his expert opinion, and as such, it should be admitted.
All right, on that basis, I will overrule the objection based on a finding that the probative value in helping the jury will substantially outweigh any prejudice of admitting the evidence.
Yes, Your Honor. Now, Mr. Pride, what did Samantha Lane tell you?
Samantha Lane indicated to me that although she was signed as a witness on the will, that she never actually observed the will being signed, and that she was not actually a witness to that will.
Now, in terms of the will itself, did you notice anything there?
Your Honor, may we be heard outside the presence of the jury?
Yes.
Your Honor, on an urgent matter, As to the marking on the exhibit, specifically highlighting portions of the will, pursuant to Rule 42, if I may read for the court, subdivision D, says prior to trial, teams may not alter, modify, change, redact, or mark on an exhibit in any way.
So what's your concern?
Your Honor, with regards to when the will was up and which would have been Plaintiff's Exhibit 3, there was a highlighted portion that was not discussed with the defense prior to trial, and is a clear violation of the rules, which specifically say that teams may not mark on those exhibits in any way. The will was not highlighted in the record.
Your Honor,
Okay, understood. Here's what I'm going to do. I'm going to instruct the jury to disregard the highlighting on the exhibit. And I think that should solve the problem. So thank you for bringing that to my attention.
Your Honor, just for clarification moving forward, my understanding was that we could have exhibits prepared for the trial. We just couldn't be marking them as the trial was going on. I don't have the rules in front of me. I'm sorry, but that was my understanding.
Your Honor, it says
Go ahead.
prior to trial, they may not be marked on in any way.
All right, here's what we're going to do. Does either side have any other modified exhibits that they are seeking to admit?
Your Honor, the defense does not have any modified exhibits that we're seeking to admit.
Okay, what about the plaintiff?
That was the last one for us, Your Honor. Again, it was just for demonstrative purposes, not that it was the actual exhibit being marked in any
I
way.
think her objection is actually, and this is a little bit late, but her objection was to the exhibit itself, not the demonstrative. Is that right?
Yes, Your Honor. And having that highlighted portion will mislead, and having it being entered into evidence will mislead the jury. And pursuant to the rules, there can be no markings prior to trial. As we clearly saw, the plaintiff's counsel did not mark anything during the time that the exhibit was being entered. So that was a marking that was clearly made prior. It was not discussed with the defense, and it is a violation of the rules.
Okay, well, I'm not totally convinced of that, but what we're going to do, as I said, is I'm going to instruct the jury to disregard the highlighting, and we will still consider the exhibit admitted, but we'll instruct the jury to disregard the highlighting, and that, I think, should resolve the issue. So thank you. You may proceed with your examination.
Yes, Your Honor. Mr. Pride, what did you find when you looked at the will?
Yeah, so when I looked at the will, I found some language that was pretty irregular from the wills that I've seen.
What language are you talking about?
Specifically, the portion that said, should I die or disappear? As you can imagine, I look at a lot of wills in the course of document examination, and over the hundreds of wills that I've looked at, I've never seen a will include the word if I die or disappear in it.
Now, Mr. Pride, did you come to a conclusion regarding the validity of the signature on the will?
I did. So specifically regarding the signature, based on the things that I mentioned before, the spacing of the letters, the shakiness of the pen on the will, and just significant differences between my samples and that will signature, my ultimate conclusion with regards to the will was that it was likely forged.
Your Honor, may I have a moment to confer with co-counsel?
Certainly.
Nothing further, Your Honor.
Okay, cross-examination?
May I proceed, Your Honor?
Yes.
Mr. Pride, I'm sorry to ask you this, but I noticed that you kept looking to the side of your screen consistently throughout your direct examination. Do you have notes in front of you?
Excuse me. No, I don't. I'm just looking at the different tiles in my Zoom screen.
Thank you, Mr. Pride. Now, you're aware of the will in this case, correct?
I am, yes.
Your Honor, may I have permission to post what has already been admitted into evidence as Plaintiff's Exhibit 3?
That's granted for both sides. Anytime there's an admitted exhibit, you may publish freely.
Yes, Your Honor. Ms. Noor Mohammadi, will you post Exhibit 3? Now, it's your opinion that Lou Donaldson didn't sign this will, correct?
Yes, I believe this will is a forgery.
Okay. So you determined that because you identified differences between this signature and the signature on prior documents, correct?
Correct.
But you would agree that no one ever signs the exact same way twice, correct?
Not the exact same way twice, but because people sign documents so often, their signature becomes fairly regular.
Now, you'd also agree that there are a variety of reasons why a person's signature might be different from one document to the next, correct?
Yes, that's correct.
For example, the person might be using a different type of pen.
That's correct.
Some pens write more smoothly than others.
Yes,
Some pens have different types of ink.
that's correct.
The amount of time a person spends on a signature could also impact how that signature looks, correct?
Yes, and that's what I saw here is that it seemed like someone was taking time to write this signature on the will.
So a person who signed rushed would sign different than someone who took their time, correct?
Objection, Your Honor, to
Yes.
speculation, if I may be heard outside the presence of the jury.
Okay.
Your Honor, counsel is asking this witness to dive into the mindset of any person who is signing a will, and as such, it is by definition speculation.
Your Honor, if I may.
Cross-examination, so I'm going to let her go ahead and ask those questions. Thank you.
Yes, Your Honor.
Overruled.
A document signed on a shaky surface would look different than a document signed on a stable surface, correct?
Yeah, if a table was, off on one leg, it would probably affect your signature. That's true.
But isn't it true that you can't tell us what writing utensil was used for this?
It was a pen of some kind, but other than that, no.
You can't tell us whether or not this person signed on a stable surface.
No, it looks pretty stable to me, but I can't be sure. No.
So the answer to my question is no, correct?
Yes.
You can't tell us how much time was spent on this signature.
No, I can't.
Now, Mr. Pride, you're an investigator, correct?
I am.
It's your job to find the truth.
It is.
To do that, you need to review evidence from as many sources as possible, correct?
That's correct.
Including reviewing documents relating to your analysis.
Yes, pertinent documents. That's correct.
Thank you, Ms. Noor Mohammadi. You can take down the exhibit. And interviewing witnesses.
That's correct. Yes.
Witnesses who are reliable.
Reliable witnesses are better. Yes.
And unbiased.
It's difficult to always get unbiased witnesses, as you can imagine. But yes, reliable, unbiased witnesses are definitely the best.
So you'd agree that a witness who has a significant financial stake in the outcome of an investigation could be biased, correct?
It's possible.
Now, you spoke with Cam Donaldson, correct?
I did.
He told you about his father's
Objection,
relationship.
Your Honor, to hearsay.
Response?
Your Honor, this is an expert. He's relied on inadmissible hearsay. And additionally, the questions that I'm about to ask will corroborate evidence that has already come in.
I'll overrule the objection on the basis of 705.
Mr. Pride, you spoke with Cam Donaldson.
Yes, that's correct. I did.
He told you about Lou Donaldson's relationship with Ms. Baja.
Yes.
He told you about an alleged prior will.
Yes,
He told you about his father's disappearance.
that's correct.
But isn't it true that you never spoke with Ms. Baja about her own relationship with her husband, correct?
I attempted to, but no, I never spoke to Miss Baja that much. As you can imagine, she knew who I was working for, so.
You never spoke with Ms. Baja about her husband's disappearance, correct?
No, again, my main reason for being hired was the handwriting analysis, so it wasn't completely necessary.
May I have a moment, Your Honor?
Of course.
Now, Mr. Pride, you remember giving a report in this case, correct?
That's correct.
That was a complete inaccurate report.
Yes.
Now, referring court and counsel to the report by Mr. Taylor Pride. Mr. Pride, isn't it true that during your report, you never once mentioned anywhere that you attempted to reach out to Ms. Baja?
Yes, that's true. As I said, I didn't think it was necessary.
Yes, Your Honor, I'm going to object to improper impeachment. The witness answered the same way he's being attempted to be impeached here.
Your Honor, if I may be heard briefly.
Sure.
Your Honor, the witness had said, and he testified today on the stand, that he attempted to reach out to Ms. Baja, yet nowhere in his report did he ever mention that he ever attempted to speak with her.
I'll overrule the objection.
Yes, Your Honor.
You never spoke with Ms. Baja about her husband's disappearance, correct?
No, I never spoke to her.
But just to be clear, at no point in your entire investigation did you ever once speak with Ms. Baja.
Objection, Your Honor, asked and answered.
Sustained.
You never spoke with other members of the Donaldson family.
I spoke to Cam Donaldson.
Apart from Cam Donaldson and Ms. Baja, you never spoke with any other members of the Donaldson family, correct?
No, from what I understood, none of them were relevant to this investigation.
So the answer to my question is no, you did not speak to any other members of the Donaldson family.
Objection, Your Honor, asked and answered.
Sustained.
Now, you just testified that it wasn't relevant to speak to other members of the Donaldson family, correct?
That's correct.
However, you're an investigator in this case,
Correct.
and you would want to interview as many witnesses as possible that pertain to your investigation, correct?
That pertained to my investigation, yes, but that doesn't mean every single person I could possibly talk to. It's only necessary for me to talk to the people who I actually need to talk to. Otherwise, I'd just be wasting people's money.
You never spoke to any other employees at Wild Wildlife,
I didn't. Again, it wasn't necessary.
but you did speak with Cam Donaldson, correct?
I did.
You're aware that Cam Donaldson is challenging Ms. Baja's inheritance of his father's estate
Correct.
worth $5 million.
That's right.
You're also aware that he's challenging the life insurance payout,
Yes, that's correct.
also worth $5 million.
Correct.
So you'd agree that Cam Donaldson has a significant financial interest in the outcome of your investigation.
Objection, Your Honor, relevance.
Overruled.
Mr. Pride, you would agree that Cam Donaldson has a significant financial stake in the outcome of your investigation, correct?
Yes, I believe that's why he hired me.
And to be clear, he's paying you today, correct?
I don't work for free.
Is that a yes, Mr. Pride?
It's a yes.
No further questions, Your Honor.
Be direct.
No, Your Honor, not based on that.
All right. Mr. Pride, thank you for your testimony today. Any further witnesses from the plaintiff?
No, Your Honor, not at this time.
All right. So does the plaintiff rest?
Yes, Your Honor, the plaintiff rests.
Okay. I think we will take a break, but before we do that, are there any motions from the defense?
Yes, Your Honor. If we could get a brief time check prior to the reading of the motion.
Sure. How does that work?
Your Honor, we are calculating the times now, and I'm conferring with the other timekeeper.
Okay. We will hold for a moment while my dog barks.
Your Honor, I have that the plaintiffs have 31 minutes and 16 seconds remaining, and that the defense has 49 minutes and 28 seconds remaining.
Okay, sounds good. Are we then ready to proceed to the motions before we take a break?
Yes, Your Honor. At this time, the defense wants to make a motion outside the presence of the jury.
Right.
Your Honor, pursuant to Federal Rule of Civil Procedure 50, the defense moves for judgment as a matter of law. Even after viewing the evidence in the light most favorable to the non-moving party, the plaintiffs has still failed to establish and prove that Karen Baja did any action that caused harm to Lou Donaldson, either intentionally or recklessly, and they failed to prove that Karen Baja did any action that harmed Cam Donaldson. For those reasons, the court should grant judgment as a matter of law in the favor of Karen Baja.
All right, response from the plaintiff.
Yes, Your Honor. Opposing counsel's motion should be denied. Viewing the evidence in the light most favorable to the non-moving party, that being the plaintiff, as this court is required to do, a reasonable jury could conclude that that the defendant should be held liable by a preponderance of the evidence. The plaintiff has presented two witnesses here today, both of which have provided sufficient direct and circumstantial evidence to fulfill all the elements of the claim brought forth here today. We heard from Mr. Cam Donaldson today, who testified as to the defendant's motive in this case, as well as Mr. Pride, who concluded that the will was forged, both of which testimonies supply the direct and circumstantial evidence to fulfill the elements of the claim brought forth here today. For those reasons, the motion should be denied.
All right, I appreciate the arguments on both sides. The court, viewing the evidence in the light most favorable to the plaintiff, finds that a reasonable juror could conclude that the plaintiff has satisfied the elements of the claim that it has asserted. Why don't we recess for 10 minutes? Is that appropriate?
Yes.
Yes, Your
Okay, so we will be back at 7:47. Okay. Is the plaintiff ready to is the plaintiff ready to proceed?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
All right. Let me just make sure that we have everybody back. All right. The defense may call its first witness.
Your Honor, the defense called Ms. Karen Baja as their first witness. May I proceed?
You may.
Good evening. Please introduce yourself and tell the court where you're from.
Good evening. My name is Karen Baja, and I'm from right here in Statesville.
Ms. Baja, I'm going to ask you the question we're all wondering here. Did you kill your husband?
Absolutely not.
Ms. Baja, I know this might be difficult, but I want to talk with you a little bit more about your relationship with your husband. How did you and Mr. Donaldson first meet?
Well, we first met when he rescued me from the side of the road. I was actually hitchhiking, and he was my Prince Charming. He picked me up, and it was love at first sight.
What happened after that?
Well, we spent that night together, and from then on, we were inseparable. And eventually, we got married.
How long were you and Mr. Donaldson married for?
We got married in 2001, so almost 12 years before he left.
And how was your marriage to Mr. Donaldson?
It was good. I mean, no marriage is perfect, but we got to work together every day and pursue our passions, and we were both bonded by our love of animals.
Now, when you said that your marriage wasn't perfect, what did you mean by that?
Well, there was some infidelity. Lou had a mistress in Costa Rica.
And how did that affect?
I'm sorry, I object and move to strike on the grounds of lack of foundation for how this witness knows that Mr. Donaldson had a mistress. We don't know how she knows this information.
Sustained.
Ms. Baja, did your husband ever, when you mentioned that you had marriage problems, do you know what those problems were?
Yes.
How do you know what those issues were?
Well, we were married, so of course we talked about those things.
And what were the problems?
There was some infidelity.
Your Honor, I object to hearsay in this case. If this witness heard that from Mr. Donaldson.
I don't think the answer called for, or the answer called for hearsay, so I'll overrule the objection.
Yes, Your Honor.
What were those problems, Ms. Baja?
There was some infidelity. He had a mistress in Costa Rica.
And how did that affect your marriage?
Well, we talked about it, and before he left, we were trying to work through it.
Ms. Baja, what kind of man was your husband?
Objection, Your Honor, to relevance.
Response?
Your Honor, this is directly going to Ms. Baja's relationship with her husband and to rebut the plaintiff's claim, that Ms. Baja had caused her husband's death.
I'm not totally sure I see the relevance of what kind of man he was. That also seems to call for character evidence. So I'll sustain the objection as to your specific question.
Yes, Your Honor. Ms. Baja, was Mr. Donaldson the type of man that was very open?
He was more of a private, kind of secretive guy.
Now, let's talk about the Emporium. You mentioned that you and your husband worked together. How long did the two of you work together?
We worked there at the Emporium for 12 years, right until the day he left.
Ms. Baja, when was the last time you saw your husband?
Around August 17th or the 18th of 2012.
Do you remember what you were doing that day?
Yes, a tiger had just given birth to some cubs a few days before, but the mother rejected them, so I was taking care of them that day.
Did you notify the police that your husband was missing?
Yes, I did, and they conducted an investigation.
And how do you know about that?
I spoke to them during the investigation.
Miss Baja, did you have any idea where your husband was?
I believe he left to go to Costa Rica.
Why do you think that?
Like I said, he had a mistress there. He also
Objection,
was
Your Honor,
always
to foundation.
I think she's already testified to that fact. Overruled.
Miss Baja, why do you think your husband went to Costa Rica?
like I said, he had a mistress there. He also was always flying back and forth to Costa Rica all the time. And he stayed off the radar because his license was suspended at that time.
Now, Miss Baja, at any point did your husband ever come back?
No, he never came back from Costa Rica. His body was never found. And
Objection,
why-
Your Honor, to the body never being found. I don't know if this witness knows what happened because of an investigation.
Overruled. I think it's within her personal knowledge whether she knows whether she's ever seen her husband's body. So overruled.
Yes, Your Honor.
Miss Baja, do you need me to repeat the question?
yes, please.
At any point did your husband ever come back?
He never came back from Costa Rica. My husband's body was never found, which is why after 5 years, I asked to have him declared dead. I needed closure.
What do you mean by you needed closure?
Well, after 5 years of hoping and praying every single day that Lou would return home, it became more and more apparent with each passing year that he was gone for good.
Now, after your husband was declared dead, what happened to his estate?
Well, based on his will, I inherited the estate, which included the Big Cat Sanctuary.
Did you receive any additional assets?
I did receive some funds from his life insurance policy.
Miss Baja, did you forge his will?
Absolutely not.
And what happened to the sanctuary after your husband left?
I started running the company like Lou wanted. He knew how much I loved and was dedicated to the sanctuary and our life's work. So he knew I would never let anything happen to it.
Thank you, Miss Baja. No further questions at this time, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. Ms. Baja, you benefited from Mr. Donaldson's death, didn't you?
Objection calls for speculation.
Overruled.
Ms. Baja, you benefited from Mr. Donaldson's death, correct?
I'm not sure what you mean by benefited exactly.
I'll explain what I mean. You made a lot of money off of Mr. Donaldson's death, correct?
It wasn't a business, but like I said, I did receive some funds.
Some funds. After Mr. Donaldson was declared dead by you, you inherited his entire estate,
Yes,
which was worth $5 million.
yes,
Not only that, but you also got an insurance payout, correct?
yes. Like I said, I received some money from the insurance.
Not just some money, it was $5 million from the insurance company, right?
Yes, that was his life insurance policy.
Right. And so you made a total of $10 million off of Mr. Donaldson's death.
I believe when you add everything, that sounds about right.
Ms. Baja, just to be clear, you would not have collected that money had Mr. Donaldson not been declared dead, right?
I wish he wasn't, but no.
Now, before you met Mr. Donaldson, you didn't have a lot of money, did you?
Objection relevance.
Overruled.
No, I came from a poor upbringing.
But when you met Mr. Donaldson, that changed
Yes,
because he was very wealthy.
he was a successful businessman. Yes,
You were very happy being married to Mr. Donaldson, correct?
I love my husband.
And but your marriage, it wasn't perfect, right?
No marriage really is.
Well, I'm just talking about your marriage. It wasn't perfect, right?
No, it's good, but not perfect.
Right, because you had certain problems.
Yes, he had his mistress.
Well, not just that, Ms. Baja. Those problems got so bad that Mr. Donaldson filed a temporary restraining order against you.
I'm aware of the restraining order he filed. Yes.
Yeah, it looks bad, doesn't it?
It does.
Objection.
Go ahead, counsel. What's your objection?
Objection relevance.
Overruled.
Now, it's also true that aside from this restraining order, request for a restraining order, Mr. Donaldson also asked you for a divorce at some point,
At one point, yes.
but you didn't want that, did you?
We were working through it, our problems, so no.
Just to be clear, you did not want a divorce from Mr. Donaldson, right?
I don't recall ever saying I did, no.
I'm not asking about what you said. I'm just asking you, you did not want a divorce from Mr. Donaldson, right?
Asked and answered.
Overruled.
No.
August 18th, 2012. You remember that day, right?
Yes.
You were taking care of the Cubs,
Yes.
and you had to leave to go to the store at some point, right?
Yes.
But you forgot your cell phone,
Yes.
and then your car broke down.
That's correct.
And this all happened at 3 a.m.
Yes, I went to go get food for the Cubs and didn't grab my phone, and then my car broke down.
Right? And because you didn't grab your phone and your car broke down, you decided to flag down a random stranger, right?
Yes.
And you decided to use their phone to make a call?
Yes. Like I said, I didn't have my phone, so I needed a call.
Right. But Ms. Baja, you can't tell us if this random person that just stopped on the side of the road to help you out at 3 a.m. was a male, right?
Objection relevance.
Response?
It goes to the credibility of this witness, Your Honor, and test the veracity of her testimony regarding what she was doing on August 18th, 2012.
Overruled.
Do you need
I don't recall.
I'm sorry. You don't recall if it was a male?
I don't recall.
I'm sure you don't recall if it was a female too, right?
Objection relevance.
Overruled.
I don't recall.
I'm sure you don't recall the cell phone you used, right?
Objection relevance.
Your Honor, same response.
Overruled.
I used a cell phone.
Yeah, but you can't tell us what that phone looked like, right?
I don't recall.
Yeah. And I'm sure you don't recall anything this person was wearing.
It was
Objection.
five.
I'm sorry?
Objection relevance.
Your Honor, this is the same line of questioning.
Yeah, the court
Your
finds
Honor-
that this, go ahead.
Your Honor, counsel is asking her about the clothes that the individual who loaned her a cell phone was wearing. It's not material, it's not relevant to proving any element in this case.
Isn't the, and we'll step outside the presence of the jury for a moment, isn't the plaintiff's theory that, or isn't, sorry, isn't it the defense's contention that the defendant was broken down on the side of the road when the decedent disappeared?
Yes, Your Honor.
Okay, so I think what the plaintiff is trying to do here is to test the veracity of that theory, and I think these questions go to that. So objections overruled.
Ms. Baja, you can't tell us one single thing about this person's appearance, can you?
It was 5 years ago. I flagged down someone random to borrow their phone. But I can't tell you details of what that person was wearing.
Right, I'm sure. And of course, you were all by yourself when this happened, right?
Yes.
Now, Ms. Baja, you do have a meat grinder at Wild Wildlife, correct?
There's one at the Emporium yes.
And you know how this meat grinder works?
There's one at the Emporium. You use it to feed animals.
You use it to feed animals, right? You've used it before?
Objection outside scope of direct.
Response?
Your Honor, this is still about what happened on August 18th, 2012, and it goes to the plaintiff's theory here about how exactly Miss Baja killed Mr. Donaldson.
I will overrule the objection. I'm not convinced it's outside the scope. Also, given the rules of the forum, it doesn't allow the plaintiff to call other witnesses in its case in chief. So I will overrule the objection.
So, Miss Baja, you work at Wild Wildlife, right?
Yes, I do.
Yeah. You know how the things at Wild Wildlife work, the different the things that you use to feed the animals.
Well, I take care of the animals and I would feed the cubs bottles.
Okay. To be specific, you know how a meat grinder works, right?
I know we have a meat grinder at the Emporium.
So your testimony here today is that you don't know how the meat grinder at Wild Wildlife works?
I'm telling you my day-to-day responsibilities don't include using a meat grinder.
That was my question. You don't know how a meat grinder works, correct?
I know we have one. I can't tell you details.
You can't tell us or the members of the jury if you know how to use a meat grinder?
Objection asked and answered.
Overruled.
I don't recall.
Ms. Baja, just for clarification here, I want you to tell the members of the jury that you don't know how a meat grinder works.
Objection argumentative asked and answered.
Sustained.
Ms. Baja, your brother Carl drove you home on August 18th, 2012, didn't he?
Yes.
Your brother Carl is a deputy sheriff?
Yes, he is.
A deputy sheriff in this county, correct?
Yes.
Now, so that means that your brother worked for the same police department that investigated Mr. Donaldson's disappearance?
Yes.
And that also means that he works for the same police department that would have arrested you had you been charged with anything.
Objection calls for speculation.
This is cross-examination. Overruled.
Yes.
Now, it's also true that after August 18th, 2012, you went to go pick up Mr. Donaldson's van at an airstrip
Yes.
with your brother Carl.
Yes.
And inside the van was Mr. Donaldson's keys
Yes.
and his glasses.
Yes.
And since, you know, you were so close to Mr. Donaldson, you of course know that he never flew without those glasses, right?
Objection speculation.
Sorry, your objection was lack of foundation.
Lack foundation calls for speculation, Your Honor.
It's cross-examination. If she doesn't know, she can say so. Overruled.
Yeah, I don't know. I didn't fly with him every single time he was in a plane.
Okay, Ms. Baja, that weekend that you were that you told us that your car had broken down and all that, that's the same exact weekend that Mr. Donaldson disappeared, right?
Yes.
Yeah, and he would go on trips every now and then, correct?
Yes.
But he would always come back, correct?
Yes.
Nothing further, Your Honor.
Any redirect?
Yes, Your Honor. Ms. Baja, after the temporary restraining order was filed, did the two of you ever separate?
No, we never got divorced.
Your husband ever filed for divorce?
No.
Now, you were asked on cross-examination about the funds that you received. What did you plan to do with those funds?
I was going to
Objection.
put all of them.
All right, counsel, what was your objection?
It was to relevance, Your Honor.
Response?
Your Honor, this witness was just asked on cross-examination about her financial motives. This question will elicit a response to rebut the defense or the plaintiff's theories, excuse me.
Overruled.
Ms. Baja, what did you plan to do with the funds that you received from the estate? And the
All of
life
it
insurance?
was, oh, sorry, counsel.
What did you plan to do with the funds, Ms. Baja?
All of it was going to go back to our life's work and to the Emporium and taking care of everything.
Thank you, Ms. Baja. No further questions, Your Honor. May this witness be excused?
She may. Defense, call your next witness.
Your Honor, at this time, we would like to read in some statements from an unavailable witness's deposition, specifically Carl Bannister.
All right, can you direct me to the appropriate page, please?
Yes, Your Honor. Carl Bannister's deposition begins on page 33 of the PDF. However, the specific portion we would like to read is on page 33, the last question, and all the way up to 34, up to the second answer.
Okay.
We would also
Sorry, go ahead.
There's also one other portion of the statement we would like to read in.
Okay.
It is on page 36 of the PDF.
Okay.
Fourth question and fifth answer on that page.
Okay, so that's the last question, right?
It is the question that starts with, did you have a chance to view any evidence or look at the reports? And then the answer immediately after that.
Gotcha. Okay. Any objection to those two statements from the plaintiff?
No, Your Honor, but at this time, we would also like to read in a portion of Mr. Bannister's deposition.
Okay. Why don't we deal with the objection? I will allow you to do that after the defense reads theirs, but as long as we're stopped, why don't you tell me what portions you want to read?
The portions that we would like to read are located on page 35 in the PDF record from lines 5 to 20. That would be the fifth cue from the third cue from the top.
The one that starts, are you aware, or are you also aware?
Yes, Your Honor.
And you want to read down to the no further questions part?
No, down to the issue was noted in a maintenance log.
Okay. Anything else?
No, Your Honor.
Any objection from the defense?
Your Honor, may I have a quick moment to quickly review those statements?
Sure.
None, Your Honor. We just ask that during the plaintiff's portion of the reading, that time be construed for their case in chief.
Yes, of course. So you may proceed with reading your portion.
May I call my co-counsel to do a Q&A of the statement?
That's fine.
When was that?
It was close to 3 a.m. She had gone out to the grocery store late at night in order to get some milk or something for some newborn tiger cubs. She had car trouble and needed a ride home as soon as possible to get back to the cubs.
Did you pick her up?
Yes, I did.
Did you have a chance to review any evidence or look at the reports?
No, I take my job seriously. I knew nothing of Lou's disappearance and I wanted to keep it that way. I was walled off from the investigation and that was fine by me.
That concludes the reading of Carl Bannister's deposition.
All right, plaintiff, you may proceed with your part.
Thank you, Your Honor. Question. Are you also aware that there is no record of your patrol vehicle moving from 3:20 a.m. until nearly 6:30 a.m., as it was showing it was near the grocery store close to Miss Baja's home during that time? Answer. Yeah, I look back at that in preparation for this deposition, and the records show that my transponder, the device that gives the location of the patrol car, was malfunctioning, cutting in and out. The issue was noted in a maintenance log, and it was replaced the next day. We have no further portions that we'd like to read in, Your Honor.
Okay, defense, call your next witness.
Defense calls Chris Raynor to the stand. May I proceed, Your Honor?
May.
Good evening.
Good evening.
Please introduce yourself and tell us what you do for a living.
Hello, my name is Chris Renard, and I am a claims investigator and forensic document examiner with Summit Life Insurance Company.
What does a forensic document examiner do?
Well, we particularly focus on relevant documents or signatures and authenticate them, make sure that there's nothing fraudulent or anything like that happening.
How long have you been a forensic document examiner for?
23 years in total now.
Do you have a specialty?
I do. I particularly specialize in handwriting analysis and other document authentication.
What is your educational experience, your educational background?
Well, I graduated with a degree in criminology, and I actually attended the Statesville Police Department Academy.
Does being a forensic document examiner require any certifications?
Yes, I'm actually certified with 2 boards, the Board of Forensic Document Examiners, as well as the Association of Certified Fraud Specialists.
Do you have any other prior experience in this field?
Well, actually, just before coming to Summit Life Insurance Company, I actually worked with the Statesville Bureau of Investigations for about 3 years, and I was a forensic document examiner in their lab as well.
And what are your duties as a claims investigator for Summit Life Insurance Company?
Well, anytime a claim is filed, I have to gather all of the relevant critical evidence. I look at accident reports or police reports if they're pertinent. I conduct witness interviews and compare any documents that might be relevant.
Have you ever been qualified to testify as an expert in forensic document examination before?
I have testified 25 times in trial before.
Now that we've talked a little bit about your background, I'd like to ask you some questions about your involvement in this case. How did you get involved in this case?
Well, I was assigned to look into this case when Ms. Baja filed her claim for the life insurance policy on Mr. Lou Donaldson, and I was supposed to investigate the circumstances surrounding Mr. Donaldson's disappearance, as well as there was a last will and testament that was, there was some concerns that it might have been fraudulent, so I looked at that as well.
How did you conduct your investigation?
Well, I sort of reached out to my contacts in the police department. I pulled documents, specifically the last will, as well as other documents which had Mr. Donaldson's signature on them. I spoke to witnesses to the signing of the last will and testament, and reviewed some other documents that were pertinent.
Let's take that one at a time. What did you learn from the sheriff's department?
Well, I was looking into if Ms. Baja was involved in the disappearance of.
Proper opinion.
Your Honor, you're on mute.
Sorry, what was your objection?
Proper opinion, Your Honor.
Hans?
Your Honor, my question was, what did you learn from the sheriff's department?
Your Honor, if I may respond.
Briefly.
We anticipate the defense expert will be seeking to offer the opinion that Ms. Baja did not have anything to do with Lou Donaldson's death. And in anticipation of this testimony, we move to limit his opinion strictly to the analysis of Lou Donaldson's signature and the forgery of the will pursuant to Federal Rule 703.
Your Honor, may I be heard? Your Honor, Chris Raynard has been working for Summit Life for 20 years. He's an expert in claims investigation. Therefore, he has the proper experience to discuss his findings from the sheriff's department.
Your Honor, if I may briefly respond.
Well, hang on a second. what opinion do you anticipate he's going to offer in response to your question?
Your Honor, I anticipate that Mr. Reynard will share information about Ms. Baja's alibi and that there were no blood or DNA found at the meat grinder, and that there was Mr. Donaldson's glasses found at his abandoned van at one of the airports.
Okay, those seem like discrete enough bases for his opinion that I will allow him to testify to that. What I won't allow him to do is to opine or parrot the police department's conclusion about what ultimately happened. So you may proceed. The objection is sustained in part.
What did you learn from the sheriff's department?
Well, I learned that Ms. Baja actually had an alibi for some of the evening of Mr. Donaldson's disappearance. Additionally, I gathered that there was no DNA found in the meat grinder at the Wildlife Emporium. Essentially, what I understood sort of one of the only pieces of evidence to be was Mr. Donaldson's glasses were left in his van that was found at the airport.
Now, drawing your attention to the signature on Mr. Donaldson's will, how did you conduct your analysis?
Well, we needed to decide whether or not this signature was fraudulent. So we pulled that signature and I looked at and compared it to two other signatures that we knew to be Mr. Donaldson's. Those were that of his driver's license, as well as one that was on the original paperwork Mr. Donaldson had filed with our insurance company back in 2005.
Your Honor, I have a copy of Mr. Reynard's signature comparison for identification. It can be found on page 40 of the record. May it be marked as Defense Exhibit A for identification.
We'll mark it as Exhibit A, yes.
Mr. Reynard, for identification purposes, do you have a copy of Exhibit A?
Let me pull it up here really fast. All right, I'm looking at it now.
For identification purposes, do you recognize it?
I do.
What is it?
This is a document I created during my investigation that compares the three signatures I was just discussing.
Is it in substantially the same condition as you last reviewed it?
It does, yeah, it appears to be the same.
Your Honor, at this time, defense moves Exhibit A into evidence.
Any objection?
None, Your Honor.
Exhibit A will be admitted.
Your Honor, may we publish this for the jury?
You may.
Mr. Reynard, after comparing these three signatures, what did you determine regarding the authenticity of Mr. Donaldson's signature on the will?
Well, I believe that there were a substantial amount of similarities between many aspects of these three signatures, both the one that was in question and the two we knew to be Mr. Donaldson's, that it's my opinion that ultimately this signature is likely genuine. That was my ultimate conclusion.
Can signatures vary?
Absolutely. There are a number of factors that play into what a signature looks like, and we always expect to see some, variations.
Can a person's signature change?
Absolutely. So, as I was mentioning, there's a number of factors that play into that. As a person ages, their signature tends to change a little bit. The speed with which they were writing at the time, even details like what sort of pen they were using can play a role in how the signature looks.
Thank you, Ms. Reed. Now, you mentioned that you analyzed the will in order to determine to contest payment. What are the grounds a company could contest payment?
Well, at the end of the day, an insurance company is a company. And so if we found any evidence to suggest that there was fraud here, we would certainly contest payment on that grounds, as well as if we believed that Ms. Baja was involved in a death or the disappearance of her husband, that as the beneficiary, that would certainly be grounds to contest payment as well.
Did you find any grounds to contest payment?
I didn't find that there were sufficient grounds, and that's what I reported to the insurance company, was that we should pay out on this $5 million policy.
No further questions at this time, Your Honor.
Okay, thank you. Cross-examination.
Your Honor, may I proceed?
You may.
Mr. Raynard, you cannot say for certain that the signature on the last will and testament is the genuine signature of Lou Donaldson.
I cannot say with 100% certainty that is true, but it does appear to be genuine.
The only thing that you can actually say is that it's close enough in this case.
Essentially, yes. I couldn't find enough evidence to say that it was fraudulent.
But someone could have forged Lou Donaldson's signature on the will.
It is a possibility, yes.
Yes, thank you. In fact, you actually had evidence that the document may have been forged.
I'm sorry, I'm not sure what you mean.
Well, you received a letter that references a Samantha Lane being coerced into signing the will.
Yes, I did receive a letter from Miss Lane after I had spoken to her in person.
Okay, well, I want to talk to you about what's in this letter. I'm directing opposing counsel to what has been bait stamped as 008, and I'm now directing the witness's attention to what has been bait stamped as 008. Mr. Renard, you
Your Honor. Please continue. Withdrawn.
Mr. Renard, you recognize this letter that has been bait stamped as 008.
I do.
And you recognize this as the letter that was signed by Samantha Lane, which was sent to you.
A letter that it claims to be from Miss Lane, yes.
And this letter is a fair and accurate copy, as you last saw it.
This appears to be a fair and accurate copy of what I received.
May the record reflect that I am remarking what has been bait stamped as 008 as Plaintiff's Exhibit 7, striking all other identifying marks. And at this time, the plaintiff moves to admit Plaintiff's Exhibit 7 into evidence.
Any objection?
Yes, Your Honor. We object on inadmissible hearsay, lacks foundation, and that this evidence's prejudicial effect substantially outweighs its probative value. May we constructively approach?
Yes, I mostly want to hear about prejudice. Why is it prejudicial?
Your Honor, we have no information who sent this letter. It's reportedly from Samantha Lane, but Mr. Raynard cannot conclusively say who wrote this letter, how it was delivered, who delivered it. This will unduly prejudice the jury if they see the contents of this letter. Because, and if I may offer, if I may provide an offer of proof, Mr. Raynard looked at the letter, but disregarded it as a hoax after he attempted to reach out to Miss Lane, but was unable to.
Response?
Your Honor, the substance of this letter may be disclosed because the probative value of the contents of the letter substantially outweighs its prejudicial effect. Mr. Raynard, the defense's expert witness, used this letter to come to a determination as to the validity of the will. And the jury needs to hear the full contents and substance of the letter to fully understand and evaluate the expert opinion of Mr. Raynard.
What's your response to hearsay?
Your Honor, just because an expert may rely on hearsay does not make it automatically admissible. There is a balancing test that must take place, and that its probative value must substantially outweigh its prejudicial effect. And here is the defense's position that its probative value does not substantially outweigh its prejudicial effect.
I understand, thank you. Ms. Vaughn, what's your response to hearsay?
Your Honor, this is an expert opinion, and pursuant to Federal Rule 703, Mr. Raynard and his expert opinion can rely on hearsay statements.
Okay, I will overrule the objection in part. I do not find that this is unduly prejudicial under the rules, but I will admit it for impeachment purposes only and not for the truth of the matter. You may proceed. So Exhibit 5 will be admitted for impeachment purposes. Sorry, Exhibit 6?
Exhibit 7, Your Honor.
Exhibit 7, I lost track. Exhibit 7 is admitted for a limited purpose.
Your Honor, defense asks for a limiting instruction to only consider this, to not consider this for the truth of the matter.
I agree that that would be prudent. The jury is instructed to not consider this for the truth of the matter, but only to consider it as to the credibility of Mr. Raynard's investigation.
Your Honor, if I may clarify, as this plaintiff still permitted to read the contents of the letter so the jury can understand and evaluate the opinion of Mr. Renard, but not for the truth of the matter asserted.
Yes, that's correct. You can use the exhibit as you see fit. Yes.
Thank you, Your Honor. If I may proceed.
Yes.
Permission to publish Exhibit 7 to the jury by way of, there we go. Now, Mr. Renard, you were the person that was investigating. Before I proceed, can you please read the letter in its entirety for our members of the jury, beginning with Dear Mr. Renard?
Absolutely. Dear Mr. Renard, I felt it was important for you to know that I wasn't being honest when we last spoke, excuse me. I was coerced into signing that will. I never saw Mr. Donaldson sign. Samantha Lane.
Now, you were the one investigating the insurance claim in this case.
That's right.
And this letter was sent to you.
It was.
And the insurance claim you were investigating was that of the will of Lou Donaldson.
That's true.
This letter talked about the will of Lou Donaldson.
It did.
And now this letter says, I felt it was important for you to know that I wasn't being honest when we last spoke.
It does say that.
Now, before receiving this letter, you told us that you spoke to Samantha Lane about the will.
Before receiving the letter, yes.
And this letter talks about that prior conversation that you had with Samantha Lane.
Yes, it does.
And as an insurance claim investigator, you would want to know all of the circumstances surrounding the signing of a will.
Absolutely.
Now, this letter specifically says, I never saw Mr. Donaldson sign.
That's true.
And you were investigating to see if this will was valid, correct?
I was.
And you would agree that if someone was forced to sign a will, that would call into question its validity.
That would certainly play a role, yes, which is why I reached out to Miss Lane after receiving this letter, but never got in contact with her.
Well, we'll get to that in a moment. Now, this letter specifically says I was coerced into signing the will.
It does.
And Samantha Lane was an alleged witness to the will of Lou Donaldson.
She had signed as a witness.
And this signature says Samantha Lane.
It does.
This letter calls into question whether Samantha Lane actually witnessed Lou Donaldson sign the will.
It does.
Objection, Your Honor. Move to strike that answer. That question specifically was introduced to prove the truth of the matter.
Being what exactly?
It
Not
didn't-
sure I understand.
Yes, Your Honor. That question specifically wasn't intended pursuant to your ruling for impeachment, but rather to show. And if I may approach.
Yes.
That question and answer was used not to impeach the witness, but instead to show the truth of the matter, that because of this letter and the contents of it, the signature in question is invalid. It is outside of the scope of what they were permitted to utilize for this letter.
Response?
Your Honor, the question simply tests the credibility of the witness and the final conclusion that he made as to whether the will was the validity of the will. We're not offering it to prove the truth of the matter asserted.
I agree. It goes to credibility. Objection is overruled.
Now, let's talk about your analysis of Lou Donaldson's signature in this case. You compared the signature on the last will and testament to Mr. Donaldson's signature on the driver's license, correct?
Yes, as well as another piece of paperwork.
And that was the signature that he signed with your office back in 2005, correct?
That's right.
So those two signatures, the one from the driver's license and the 05 policy, those matched.
They did.
But there was a difference between those two and the one on the last will and testament.
There were some differences, yes.
Now, you mentioned on direct that there are multiple reasons why a signature may change over time, and I want to talk to you about those reasons.
All right.
Now, you said a change in health may cause a signature to change.
Certainly, a change in age, health.
But you never followed up with any of Mr. Donaldson's doctors to see if his health had changed.
No, I did not.
You never specifically asked his son about his health.
I don't recall ever specifically asking his son, no.
And you never specifically asked his wife about his health.
No.
Now, you said that care when signing can affect the signature, right?
That's true.
But you weren't physically present when he signed it.
I was not physically present.
So you can tell us that he was in a hurry.
I can't tell you anything about what he was doing at the time he signed.
Because you weren't there. And there are only 2 witnesses that you could have asked about the will, correct?
That's right.
And the first, you just told us you dismissed as a hoax when she told you she was coerced into signing.
I dismissed the letter, yes.
And the second is the defendant,
That's true.
who is also the sole beneficiary of this $5 million life insurance policy.
That is true.
Let's talk about your investigation into this policy. Part of your job as an insurance claim investigator, you review wills.
I do.
And in your 20 years at Summit Life, you've reviewed hundreds of wills.
That's right.
And not once in those 20 years at Summit Life have you ever seen another will that contained the language, "if I disappear."
That is true. This was an unusual will for sure.
Unusual. So it's true that your final recommendation was to pay the proceeds of the life insurance policy.
Yes, after conducting my investigation, I didn't think there was enough evidence to say that it was fraudulent.
You decided to pay the proceeds even though you had your suspicions that the language was unusual, like you just said.
Yes, I did recommend that the insurance company pay the $5 million policy.
You decided to pay the proceeds even though you can't say for certain that the signature is genuine.
That is true.
And you decided to pay the proceeds even though you had a letter from Samantha Lane that said the will was a forgery.
I did tell the insurance company that we should pay out on the proceeds.
One moment, Your Honor. Nothing further.
All right, any redirect?
Yes, Your Honor. Mr. Raynard, did you investigate into Samantha Lane's letter?
I did. I had spoken with Miss Lane prior to receiving that letter, and she had told me that she witnessed the will being signed. When I received that letter, I reached out to her, but was unable to get in contact with her. And, on balance, I was concerned about that letter's credibility.
And so what did you do with the letter afterwards, after you attempted to reach out to Miss Lane?
Well, I disregarded it. I assumed that it was not genuine.
No further questions, Your Honor. May this witness be dismissed?
You may. Thank you, Mr. Renard. Any further evidence from the defense?
None, Your Honor.
All right, so the defense rests, is that correct?
Yes, Your Honor, the defense rests.
Okay, and I assume that the defense renews its motion under Rule 50, and I will deny it for obvious reasons. Are the parties ready to proceed to closing argument?
Yes,
Yes.
Your Honor.
All right, then why don't we go ahead and do that? Closing argument from the plaintiff.
Yes, Your Honor. Before I proceed, may I reserve time for rebuttal and get a time check too, if that's okay?
I think that's a sensible idea. Let's go ahead and do a time check.
Your Honor, we have 16 minutes and 30 seconds remaining for the plaintiffs, calculating the defense now. And Your Honor, 36 minutes and 24 seconds remaining for the defense.
Okay, would either party like a 5-minute warning via, I guess we could do it via chat, or do you feel comfortable with where you're at?
The plaintiff is comfortable, Your Honor.
Okay.
Defense is comfortable as well.
Okay, then let's proceed. Closing argument from the plaintiff.
Yes, Your Honor. $10 million. The defendant killed her husband for $10 million. That's the only reason we're here today, members of the jury. And that's the only reason why Cam Donaldson sits before you today without a father. All because the defendant let her greed get the best of her. They say money makes people do crazy things. Well, the fear of losing money and the selfish desire to keep it no matter what, well, that drove the defendant to create a plan to kill Mr. Donaldson, take his entire estate, and cover it all up. 2 days after Mr. Donaldson asked the court for a restraining order against the defendant, she forged his will. 2 weeks after Mr. Donaldson threatened the defendant with a divorce, he mysteriously goes missing without a trace. And it took 2 months from the day that Mr. Donaldson filed that restraining order to the day he went missing for the defendant to think of and carry out her plan to make sure that the lavish lifestyle she had become accustomed to wouldn't be stripped away from her by a divorce. You see, the defendant didn't just want a cut. She wanted everything, all 10 million of it. And she was going to do everything in her power to get exactly what she wanted. And unfortunately, she did. Because when the defendant realized that Mr. Donaldson wanted her out of his life, she decided to take his instead. At the beginning of today's trial, my co-counsel Alice Vagan came before you and explained that we as the plaintiffs have the burden of proving by a preponderance of the evidence that the defendant should be held responsible for wrongfully causing Mr. Lou Donaldson's death. Now, preponderance of the evidence, in other words, means more likely than not. So imagine you're looking at a scale that appears to be even. Then put one feather on one side of the scale and it slightly tips. That right there is preponderance. And now at the end of this trial, after seeing all the evidence and hearing all the testimony, it has become clear that we have met our burden and that the defendant should be held responsible for wrongfully causing Mr. Lou Donaldson's death. Now, in a few moments, the judge will instruct you on the law. But before he does, I'd like to discuss it with you. We as the plaintiffs had to prove these 4 elements: that Lou Donaldson is dead, that the death of Lou Donaldson was caused by the defendant's intentional or reckless conduct, that the plaintiff Cam Donaldson suffered injuries, damages, or losses as a result of the death of Lou Donaldson, and that the defendant's conduct, either intentional or reckless, was the cause of the plaintiff's injuries and damages. Now let's go through each one of these elements and see just how all of them have been proven in today's case. Starting with number 1, that Lou Donaldson is dead. Now we heard today that Mr. Donaldson has been declared legally dead. To be specific, he was declared legally dead by none other than the defendant. Now, to be clear, just because Mr. Donaldson has been declared legally dead doesn't automatically mean we met the first element here. But consider that fact along with the other evidence we have in this case. We know that Mr. Donaldson hasn't been seen by anyone since August 17th, 2012. He built Wild Wildlife from the ground up. He worked hard every single day and he loved his son very much. There is just simply no reasonable explanation for why Mr. Donaldson would have left his entire life behind without saying anything to anyone, including his son, other than the fact that he is dead. And as a result, we have proven the first element in today's case. Now, I want to look at elements 2 and 4 together, because if the defendant intentionally caused Mr. Donaldson's death, she intentionally caused damages to Cam Donaldson. Members of the jury, we know that the defendant is the only person in this entire case with a motive to kill Mr. Donaldson and the only person with the resources to get it done. Simply put, all the facts point to the defendant being responsible for causing Mr. Donaldson's death. Now, in a few moments, opposing counsel will come before you and try to make you believe that it would be absolutely ridiculous to think that Ms. Baja wanted to kill Mr. Donaldson, let alone be able to carry out such a plan, all while leaving no evidence behind. But if you look at all the pieces of the puzzle here and use your common sense, it becomes clear that the only reasonable conclusion you can make is that the defendant, consumed by greed and in fear of losing her newly acquired wealth to a divorce, killed Mr. Donaldson and made it seem like she had absolutely nothing to do with it. So let's take a look at that evidence and see just how all the pieces of the puzzle fit together. Now, we heard about how Mr. Donaldson and the defendant met, how they were 20 years apart, how when they met, Mr. Donaldson was very wealthy and the defendant was not. You see, she came from a poor upbringing, but when she met Mr. Donaldson, her life changed. She hit the jackpot, and she knew it too. Now, we know that she was only in it for the money from the very beginning. That's why Cam and the defendant herself told you that their marriage had problems. That's why Mr. Donaldson wanted a divorce, but the defendant didn't. That's why Mr. Donaldson went to court and tried to get a restraining order against the defendant. Think about that. Mr. Donaldson feared for his life to the point where he went to court and asked the judge to order the defendant to stay away from him because he didn't feel safe around her. You don't have to just take my word for it. Read what the defendant wrote. Read what Mr. Donaldson wrote himself. He said that I am seeking a divorce from Karen Baja. I do not feel safe around Karen Baja. This is what was going through Mr. Donaldson's head on June 12th, 2012. This is what Mr. Donaldson was thinking just 2 months before he was ever last seen alive. And now, members of the jury, we know that Mr. Donaldson was justified in bringing this restraining order here. Now that we have the defendant's intent in mind, let's see how she acted on that intent, because the question still remains. How did she do it? Well, members of the jury, we know now that Miss Baja killed Mr. Donaldson by putting him in the meat grinder and feeding him to the cats. And as crazy as it sounds, it is the only reasonable conclusion we can come to. So let's look at the facts. We know that the defendant was at Wild Wildlife in the early morning hours of August 18th, 2012. The last time anyone ever saw Mr. Donaldson alive was on the night of August 17th, 2012. The fact that Mr. Donaldson disappeared that very same weekend is no coincidence. Now, the defendant told us that there's a meat grinder at Wild Wildlife. And when I questioned her about that meat grinder on cross-examination today, she apparently has no idea how the meat grinder at Wild Wildlife works, even though she claims that Mr. Donaldson left her everything because she would be the best person to take care of his business. How can that be possible? You know why Miss Baja couldn't answer my questions? It's because that's exactly what she used to kill Mr. Donaldson. Now, we also heard that she was with her brother that night, the deputy sheriff. Her brother, who works for the same police department that would have arrested her had she been charged with anything. Cam told us that in the early morning hours of August 18th, he arrived at Wild Wildlife to the scene of a break-in with the lock cut and the gate broken into. He told us that when he got there, he saw the defendant with another individual. The individual was carrying a lock cutter, and the defendant was carrying the lockbox that contained Mr. Donaldson's real last will and testament. The fact that Cam saw her there that morning is absolutely no coincidence. Now, speaking of that will, we heard from Mr. Pride today, an expert in the field of forensic document examination, who explained to us the process he goes through in investigating forgery cases. He told us that when he applied that process to the facts of this case, he concluded that the will was forged. He also told us that during his investigation, he noticed that the will leaves everything to the defendant should Mr. Donaldson, quote, die or disappear. He told us of the hundreds of wills he's looked at over his career, he has never seen that language before. And you know why? It's because people don't plan on disappearing, members of the jury. We know that Mr. Donaldson didn't write that in his will because it was forged by the defendant as part of her plan to kill Mr. Donaldson, take his entire estate, and just act like she had nothing to do with it. The defendant told you herself that while Mr. Donaldson used to go on trips every now and then, he would always come back. But this time he didn't. And it wasn't because he just disappeared. It's because the defendant killed him. Because we know that the defendant intentionally forged Mr. Donaldson's will and intentionally acted to kill him, we know that she intentionally acted to cause damages to Cam Donaldson. And as a result, we have proven elements 2 and 4 in this case. Now for element 3, the damages caused to Cam Donaldson. Members of the jury, this element is undisputed. Cam suffered one of the biggest losses imaginable, the life of a loved one. He worked with his father almost every single day, and of course loved him very much. Now, because of the defendant, he will never be able to see his father again. As a result, we have proven each and every element in the claim brought forth here today. Now, the loss that Cam suffered is a loss that he will never be able to fully recover from. More importantly, it's a loss that he never should have had to suffer. But you see, this is what the defendant wanted. Cam lost his father, so the defendant could win $10 million, and that's just not right. But you have a chance to correct that. And when you go back to deliberate today, you're going to get a verdict form that's going to ask you to assign a dollar amount to what you think is equal to the damages Cam has suffered in this case. To be clear, no amount of money in the world will ever make Cam whole again for the loss of his father, but this is the closest thing that the law offers to making that happen. That is why I suggest that you return a verdict of $25 million in favor of Cam Donaldson today. Members of the jury, up until now, the only person that has suffered the consequences of the defendant's actions has been Cam. You have the power to change that. You have the power to make it right. Find the defendant liable. Thank you.
All right, thank you very much. Closing argument from the defense.
Yes, Your Honor. Members of the jury, there is one thing both plaintiff's counsel and I agree on, that the death of Lou Donaldson was devastating for everyone who was close to him. For Cam Donaldson, who lost his father, and for Miss Baja, who lost her husband and partner in Big Cat Rescue. But grief is not a valid reason to bring a lawsuit. And yet that's exactly what Cam Donaldson did. When Miss Baja lost her husband, she devoted herself to preserving and caring for her big cats. When Cam Donaldson lost his father, he looked for someone to blame to avoid the stark reality that his father chose to leave him. That's why he's here today accusing Miss Baja of murder. But in this courtroom, in this country, you can't just make accusations. You have to prove them. And here, even though Cam Donaldson can point his finger, he cannot prove the case. The plaintiff was required to prove their case to you by what the law calls the preponderance of the evidence. Now, to understand what that means, imagine a scale. On one side, place all of the evidence plaintiff provided to you, and on the other side, place the defense's evidence. If, after carefully weighing the evidence, the scale tips in our favor, even by the weight of a feather, or that it's perfectly even, then you must find Karen Baja not liable. Ms. Reed, please display the jury instructions. Today, the plaintiff was required to meet their evidentiary burden on 4 separate elements. First, Lou Donaldson is dead. Second, the death of Lou Donaldson was intentionally or recklessly caused by Karen Baja. Third, the plaintiff suffered injuries. And fourth, the defendant's conduct resulted in the plaintiff's injuries. Now, the plaintiff can't just prove these as possible. They have to prove these as probable. Thank you, Ms. Reed.
If the plaintiff fails to meet their evidentiary burden on even one of these claims, then you must, not may, must return a verdict in favor of Karen Baja. But today, the plaintiffs have failed to meet their burden for two reasons. First, Lou Donaldson chose to leave his wife and son on August 17, 2012. And second, Lou Donaldson chose to leave his estate to Karen Baja. So let's talk about that first point. Lou Donaldson chose to leave his wife and son on August 17th, 2012. It's hard being the one left behind. Karen, you heard testimony today about how close Cam Donaldson was with his father. But Cam Donaldson couldn't accept the reality that his father chose to leave him. That's why he's here today accusing his stepmom of murder. But members of the jury, Cam Donaldson isn't a police officer or a lawyer or judge. This isn't a criminal trial. Ms. Baja hasn't even been charged or convicted of any criminal offense relating to Lou Donaldson. Now, what you did hear today is of a police investigation, but you didn't hear anything about a murder weapon, evidence that Karen Baja harmed or even killed Lou Donaldson, or any evidence of a body being found. But despite that, Cam Donaldson cannot accept that Karen Baja was uninvolved in his father's disappearance. He's here accusing her of murder, but hasn't brought you a shred of evidence to support that. There is one thing plaintiff proved to you, and that's August 17th, 2012 was the last day anyone in the United States saw Lou Donaldson. And that's because after that day, he chose to leave. Mr. Donaldson has both the means and motivation to leave his life in the United States behind and move to Costa Rica. You heard today that he owned multiple planes, but that no one really knew how many. And that months before his disappearance, he had a suspended pilot's license and had a tendency to fly without logging any flight plans with any of the local airports. Mr. Donaldson had the ability to pick up and leave. And the methods he chose meant that nobody would be able to trace whether or not he made it to his destination. Now, Mr. Donaldson also had a history of leaving everything for a woman he was in love with. He did it first when he met Karen Baja. When he met Karen Baja, he chose to leave his wife and son behind. And as you heard today, he found a new love in Costa Rica. And once again, chose to leave everything to pursue that new relationship. Now, the plaintiffs have tried to paint Ms. Baja as a gold digger, but that's not true. Karen Baja thought Lou Donaldson was her soulmate. She was devoted to him, and their love was rooted in their shared passion of big cats. Lou Donaldson's choice to leave was devastating for everyone. For Lou Donaldson, for Cam Donaldson, who lost his father, and for Ms. Baja, who thought Lou Donaldson was her soulmate. And she thought he felt the same. Now, plaintiff has spent 2 hours trying to point the finger at Ms. Baja, but has failed to bring you any evidence of these wild accusations of murder. In fact, Ms. Baja didn't even see her husband the day he left. She was busy devoting herself to 2 baby cubs that had been rejected by their mother. You heard today how Karen Baja took care of those cubs into the night and had to run to the store to get them milk. And when she went to the store, her car broke down and she had to ask her brother for help. Now, a question you might be asking yourself is, why didn't Karen Baja call her husband when her car broke down? Well, the truth is, Karen Baja knew her husband like she knew the back of her hand, which meant she was well aware of his tendency to hop on one of his planes and leave town. Now, we all have one of those friends who we call and we text and we don't get a response for a few hours, sometimes even a few days. And when you're in an emergency situation, stranded on the side of the road, those people aren't going to be the ones you call. You're going to call someone who you know will answer your phone and be available to pick you up. Now, plaintiffs have tried to turn this into a murder mystery, but instead of bringing you a smoking gun or a bloodstained knife, all they've brought to you today is a transponder that may or may not be working. Carl Bannister works for the sheriff's department, and they didn't find his behavior or the malfunctioning transponder suspicious. And it's their job to determine what is or isn't suspicious. So why are we here today? Two reasons: grief and greed. Today you heard about the pain Cam Donaldson suffered losing his father. He couldn't accept that his father chose to leave him. But instead of accepting the truth, he's decided to channel his denial into a murder mystery thriller where he doesn't have to accept a single ounce of blame or accept the truth that he was abandoned. He thinks he's entitled to the entire company. He couldn't accept the possibility that his father cut him out. Which brings me to my second point. Lou Donaldson chose to leave his estate to Karen Baja. Karen Baja wasn't the only one tricked into believing her relationship with Lou Donaldson meant something more. Cam Donaldson thought he had a close relationship with his father. But the point is, he was an assistant for 20 years. 20 years, scheduling meetings and taking phone calls, not taking care of the animals or running a business like a true partner. He thinks he's entitled to the entire company, but that's a job he's entirely unqualified for. The only person who had the experience to fully run Wild Wild Life was Karen Baja. And that's exactly why Lou Donaldson chose to leave it to her. Now today, Cam Donaldson is contesting Mr. Donaldson's last will and testament and Ms. Baja's receipt of the $5 million life insurance policy. Together, that's a total of $10 million. 10 million reasons to bring this lawsuit. So let's take a look at the will first. The plaintiff wants you to find the will invalid because there's some differences between the signature on Mr. Donaldson's will and the handwriting samples. Now, today you heard from two experts, Chris Reynard, a claims investigator from Summit Life Insurance Company, and Taylor Pride, the plaintiff's own expert, that no two signatures are ever the same, and that signatures can vary based on the writing utensil used, where it was signed, or if the author was rushed. Now, no one here is contesting there are some differences between the signatures, but no one here can tell you what kind of pen Mr. Donaldson used, where he signed, or if he was wearing his glasses. These minor differences are not enough to contest the authenticity of the will. Now, plaintiff also wants you to find the will invalid because there's some unusual language in the will. That language they're talking about is die or disappear. Now, no one here is contesting that that language is unusual, but Mr. Donaldson didn't live a normal life. He was a multimillionaire with multiple planes and a history of leaving one life behind to start another. The evidence suggests that he wanted to disappear. He knew there wasn't going to be a body because he wasn't planning on dying. He was planning on disappearing. And that's exactly what he did. So while that language might be unusual for someone like you or someone like me, for Mr. Donaldson, it was deliberate. Now, the plaintiff also wants you to find Ms. Baja's receipt of the $5 million life insurance policy invalid. They are contesting that. Now, today, you heard from two experts, Chris Reynard and Taylor Pride. Taylor Pride was hired by Cam Donaldson and paid by Cam Donaldson. Chris Reynard works for Summit Life Insurance Company. It was his job to find a way out of paying Karen Baja. Now, if you have any experience with insurance companies, you know how difficult it can be to get a payout on a claim. Chris Reynard investigated the circumstances around Lou Donaldson's disappearance and investigated the last will and testament and didn't find any indication whatsoever that payment to Ms. Baja was unwarranted. Mr. Donaldson simply could not accept that his father cut him out. And in the plaintiff's search for the perfect scapegoat for his grief, he hit gold. By pegging Ms. Baja with his father's his father's murder, he would become his father's heir, making him the sole beneficiary of a $5 million company and a $5 million life insurance policy. Now, you heard today about a prior will and how that prior will gave Cam Donaldson 25% of his father's estate. But today, he's done only getting a portion of what he thinks he deserves. Today, he wants it all. But he hasn't provided you a shred of evidence to support he's entitled to anything. Ms. Reed, may you please display verdict form B? Now, after I'm done speaking, plaintiff will have another opportunity to speak with you. And after that, you'll receive 2 verdict forms, but you only need to sign 1. This is the verdict form that deserves your signature. Thank you, Ms. Reed. Now, as you learned throughout today's trial, it was easier for Cam Donaldson to believe that someone took his father than to accept his father chose to leave. It was easier for Cam Donaldson to believe he was entitled to the entire estate than to accept he was never more than an assistant. It was easier for Cam Donaldson to believe that the last will was forged than to accept his father cut him out. But you aren't called today as jurors to do what's easy. You're called to do what's right. Today, we ask for the just verdict, the right verdict, a verdict finding Karen Baja not liable.
All right, thank you very much. Rebuttal?
Yes, Your Honor. Mr. Donaldson never left his entire life behind without saying anything. Never. Cam told us today that his dad would always come back. The defendant herself told you today that he would always come back. In the real will we heard about today, the will split Mr. Donaldson's estate 4 ways: to Cam, his old wife, Karen, and his foundation. So no, he never had just picked his entire life up without saying anything and just left it behind like that. Now, opposing counsel came before you and harped on the fact that there was little evidence in this case. Members of the jury, when you're deliberating today, I want you to remember the jury instruction that talks about circumstantial evidence. So let me read that to you. Instruction number 10 reads that evidence may be direct or circumstantial. Circumstantial evidence is the proof of facts or circumstances from which the existence or non-existence of other facts may be reasonably inferred. All other evidence is direct evidence. The law makes no distinction between the effect of direct evidence and circumstantial evidence. Members of the jury, in other words, the pieces of the puzzle in this case is the circumstantial evidence. And your common sense are the reasonable inferences that pull them all together. Opposing counsel also wants you to believe that because no body was ever found, we can't prove that there's a death. Members of the jury, we don't need proof of a dead body. There's no signs of him being alive anywhere. He didn't say anything to his son. He didn't say anything to anyone. The only reasonable conclusion is that he's dead. Now, I also want to talk about the day of August 18th, 2012. We heard about the defendant's alibi that day, that she went to the store at 3 a.m. and forgot her phone, and then some random person pulled over and helped her out. And then when I confronted her about that alibi on cross-examination, what did she tell us? Nothing. She couldn't remember anything about what the person's appearance was, the phone that she used, the car that he was driving, nothing. And why? It's because she's trying to hide something from us. And we know now that what she was trying to hide is the fact that she killed Lou Donaldson that night. But opposing counsel wants to point the finger at Cam. Members of the jury, the right decision in this case is to find the defendant liable. Thank you.
All right, thank you very much. The case will be submitted. thank you to all of the participants and the scoring jurors, to the two teams. This is the new world, and there are a lot of lawyers with a lot more experience than you guys that could not handle this, what you just did with a tenth of the skill that you have. So I hope you feel really proud of how you have mastered the technology and mastered the new world. I think that certain things I think will go back to normal someday, but I think that virtual hearings at least are here to stay, particularly in certain practice areas. So this is a skill that's going to serve you guys very well. And I just want to also say I appreciate all the hard work that all of you put into it, and good luck the rest of the way. It was a pleasure to watch all you guys.
Thank you very much.
Thank you so much.
Thank you.
All right, have a good evening.
As well. Thank you.
Get some rest.